Stream audio check. Stream audio check.
I heard that. Worked.
This is the evidentiary hearing in the matter of the 11th Prudence review of costs subject to the commission-approved fuel adjustment clause of Evergy, Missouri West, Inc., DBA Evergy, Missouri West. I am Ron Pridgin. I'm the regulatory law judge assigned to preside over this hearing. It's being held on May 22nd, 2024 in the Governor Office Building in Jefferson City, Missouri. The time is 9:03 a.m., 9:04, excuse me. I would like to get entries of appearance from counsel, please, beginning with the company.
Thank you, Your Honor. Let the record reflect the appearance of Jackie Whipple and Roger Steiner. Our contact information has been provided to the court reporter.
Mr. Steiner, thank you. Entry on behalf of the staff of the commission, please.
Yes, Judge, appearing on behalf of staff, Jeff Keevil. Address is 200 Madison Street, Jeff City, Missouri, 65201.
Mr. Keevil, thank you. On behalf of the Office of the Public Counsel, please.
John Kleiser, on behalf of the Public Counsel. My contact information is with the court reporter.
Very good. Thank you, Mr. Kleiser. Have I overlooked anyone? All right, just a couple of housekeeping matters before we proceed to opening statements. Agenda is at noon today. I will break well before noon to give everyone a chance to clear the room if they would like, and others to join because agenda is being held in this hearing room today. And so I will look for a natural stopping point somewhere between 11:30 and 11:45. If I cannot find one, I will probably simply cut off a witness or counsel, and I apologize in advance, but we do need to give time to have agenda started in this room, and we will plan to resume at 1:30 unless instructed otherwise. Also, we will not be going late. I don't anticipate we'd be able to finish the hearing today anyway, so we will be wrapping up no later than 5 and finish the hearing tomorrow unless we get through all the witnesses today. Does counsel have anything for me or anything from the bench before we proceed to opening statements? All right, hearing nothing, I believe according to the list of opening statements filed by the parties that Evergy would go first. So if there's nothing further from the parties, Mr. Steiner or Ms. Whipple, whenever you're ready.
May it please the Commission? My name is Jacqueline Whipple with the law firm of Denton's U.S. LLP. Today, Roger Steiner of the company and I will represent Evergy, Missouri West, EMW, in this proceeding. We may also refer to the entity as Evergy or the company. In accordance with the Commission's order approving stipulation dated May 2, 2024, this case now only involves the 11th Prudence Review for EMW's Fuel Adjustment Clause costs for the audit period of June 1, 2021 to November 30th, 2022. In addition, staff no longer recommends any disallowance for this proceeding. An FAC, a Fuel Adjustment Clause, is a clause filed as part of an electric utility's tariff. The FAC allows the utility to increase or decrease the charge for power to consumers when the utility's corresponding fuel costs have increased or decreased. The company's tariff provides as part of its FAC that prudence reviews of the FAC costs shall occur at least every 18 months, which also attracts the associated statute and commission rule. In this proceeding, the Commission will determine whether the company's FAC costs were prudently incurred during the audit period. For such determinations, the Commission has established its prudence presumption and standard. The Commission's historic prudence presumption and standard have been approved by the Missouri Court of Appeals for years. The first step for the Commission's determination is the prudence presumption. And you can see on the screen, the presumption is a utility's costs are presumed to be prudently incurred. Under Missouri law, this presumption may only be overcome by a party who creates a, quote, serious doubt about the company's prudence. In this proceeding, the record will show that OPC has not successfully overcome the prudence presumption. As a result, the Commission does not need to move to the next step to consider its prudence standard, since the prudent presumption has not been overcome. But even if the Commission does consider the prudence standard, the competent record evidence on the whole will also show that the company's FAC costs were prudently incurred. The prudence standard requires the Commission to determine whether the company's conduct was reasonable at the time, under all of the circumstances, while considering that the company had to solve its problem prospectively rather than in reliance on any hindsight. That determination involves a two-pronged test. Prong one, did the company act reasonably at the time under all of the circumstances? Prong two, was any imprudence the direct cause of increased costs to customers? To answer those questions, and certainly before ordering any disallowance, the Commission must determine if the party requesting a disallowance satisfied its burden of proof for each prong of this test. In this case, the party with that burden of proof is OPC, and it has not been satisfied. The company will be presenting 3 witnesses to explain this proceeding and to answer your questions. First, you will hear from Kayla Messamore, Evergy's Vice President of Strategy and Long-Term Planning, who provides the company's response to OPC's proposed disallowance as related to the company's resource planning. John Reed, the Chairman and CEO of Concentric and CE Capital Advisors, provides the overview of the prudence standard applicable to this case and responds to the prudence assessments and proposed disallowance of OPC. Darren Ives, Evergy's Vice President of Regulatory Affairs, is the company's concluding witness, giving an overview of OPC's position in this proceeding and the company's response thereto. In this case, the record evidence shows that OPC improperly relies upon hindsight to claim imprudence. But this commission knows how to identify arguments that are improperly based on hindsight and to disregard them. For example, in a 2018 prudence review for Empire, the commission noted, "It is very easy to look back at market prices with perfect 2020 hindsight to say that a utility's decision cost ratepayers a certain sum of money." OPC claims EMW was imprudent by not providing a hedge against energy markets with its own generation, and that EMW and its sister company, Evergy Missouri Metro, or EMM, should be combined to supposedly combat fuel cost increases far into the future. But OPC improperly cites its own speculation, along with market information beyond what was available during the company's decision-making that occurred years before the audit period at issue. That's improper hindsight, as well as purely unsupported opinion. Even if the commission was to consider OPC's analysis, it's plainly flawed on its face. OPC's attempts to calculate speculative costs if EMW and EMM were combined failed to justify that as a result, EMM's customers would be forced to pay the hypothetical costs shifted away from EMW's customers. The Commission has already rejected OPC's same arguments in past cases and proceedings, and should do so again here, as Mr. Ives and Mr. Reeves will testify. Accordingly, OPC's proposed disallowance in this case should be rejected. The Commission should not adopt OPC's proposed ordered adjustment of $86,376,294 with interest to be applied to EMW's next fuel adjustment rate, or FAR, filing. OPC violates the prudence standard and fails to offer any competent evidence of any imprudence in the company's past resource planning or decision-making during the audit period at issue. Even staff, in its pre-file testimony and position statements filed in this proceeding, disagrees with OPC's proposed disallowance. In fact, staff agrees that EMW was not imprudent when relying on the SPP energy market and is, quote, unsure of what a reasonable disallowance would be based on the number of variables needed to quantify any associated amount. The company's decisions regarding generation or the SPP market were prudently based on its long-term integrated planting analysis, and OPC has not shown otherwise, as Ms. Messamore will testify. Even so, under Missouri precedent, the company cannot be punished for changed market conditions outside its or any other utility's control, as Ms. Messamore will also testify. In this case, what's not in dispute is crucial to a proper application of the Commission's established prudence presumption and standard. The record evidence will show there is no dispute by any party that the company was prudent in its decision-making during the audit period at issue. That alone is dispositive of this proceeding. There is also no claim by any party of imprudence as to any specific decision by the company during its past resource planning. Therefore, OPC has not shown with competent record evidence, on the whole, any imprudence by the company, much less any imprudence that satisfies the required two-prong test. No disallowance should be ordered in this case, and instead, the company should be permitted to recover its prudently incurred FAC costs. If there are no questions, thank you so much.
Ms. Whipple, thank you. Let me double check with the bench. Any bench questions? Chair Hahn, any questions for the company?
No questions, Judge.
All right, thank you. Commissioner Holzman?
None at this time, Judge. Thank you.
Thank you. Commissioner Kolkmeyer? Commissioner Mitchell, any questions for the company? All right, counsel, thank you.
Thank you.
Opening statement from staff. Mr. Keevil, when you're ready.
Judge, if I could do my opening statement from here, I would appreciate it. It'd
Certainly.
probably take me longer to get up and down than it would to give this opening statement.
Absolutely.
Good morning. May it please the commission. As Ms. Whipple referred to, on March 11th, 2024, staff, Evergy, Missouri Metro, and Evergy, Missouri West submitted in case numbers EO 2023-0276 and 0277 a non-unanimous stipulation and agreement. No party objected to that stipulation, so the commission treated it as unanimous. On May 2nd, 2024, the commission issued an order approving the stipulation, which order became effective on May 12th, 2024. Therefore, that stipulation is already in effect. That stipulation resolved all issues which existed between Evergy Metro, Evergy West, and staff in both of the referenced cases. The only remaining issues, therefore, in these cases are issues raised by OPC in EO 2023-0277 between OPC and Evergy West. Therefore, staff does not plan to be involved in this case as it normally is. We do have one witness on the issues remaining for decision, Mr. Jordan Hull, but we basically view this matter as being between company and OPC at this point. Thank you. If you have any questions, I'll take a shot.
Mr. Keevil, thank you. Any questions for staff counsel? All right, Mr. Keevil, thank you very much. Opening statement from public counsel. Mr. Kleiser, when you're ready, sir.
Sorry, want to make sure that was working. If it please the commission, hello, my name is John Kleiser. I am presenting the opening statements on behalf of the Missouri Office of the Public Counsel. So I feel the best place to start here is to simply begin by explaining what the OPC is arguing in this case. And in a nutshell, the OPC's argument is that a prudent utility operating inside an RTO, or Regional Transmission Organization, would try to match the amount of energy that it generates to the amount of energy it buys off the RTO energy market. And the reason we argue that this is a prudent decision is because it would allow the utility to significantly mitigate the impact of price volatility in the RTO market. Now, in order to better understand that, we want to talk about what an RTO, which again is a Regional Transmission Organization, is and how that operates. And because we have a newer commissioner, I'm just going to start from the beginning, right? So an RTO is an aggregator of multiple electric utilities, and its primary function is to coordinate a multi-state electric grid. And a key part of this is to operate an energy market that allows all the electric utilities in the RTO to buy and sell energy into the market. Now, how this works in practice is that an electric utility in an RTO buys all of the energy it needs to serve customers from the RTO. However, at the same time, the electric utility sells all the electricity it generates into the RTO energy market. And because everyone is buying and selling into the same pool, the RTO can set prices and ensure that everyone has energy in the most efficient way possible. But for an individual electric utility, the market has an additional benefit in that that utility can use what it sells into the market to offset the cost of what it's buying from the market. And this is extremely important because the RTO energy market, like all markets, is subject to price volatility. So being able to cover its costs by selling into the market at the same time you're buying allows the utility to insulate itself from price volatility. And the best way to think about this is to think of it just like having insurance, right? If you own a home, you buy a homeowner's policy to protect against the damage from your home. When you do that, you're not thinking, well, I know my home is going to get damaged. You're not thinking, I'm going to make a profit off this insurance policy. You're thinking, I need this to protect against the risk of something going wrong. The same concept applies to the RTO market. If you own generation and can sell into the market, you can offset the cost of buying from the market and therefore prevent the risk of price volatility from having an impact on you. And you can actually see this in practice if you look at Evergy West's sister utility, Evergy Metro, which was kind of discussed by the company itself. So what you see right here is a graph that shows the total amount of energy sold into the market divided by the total amount of energy bought from the market for Evergy Metro. And what you'll see is that for Evergy Metro, they're averaging well above 100%, which just means that they're selling far more than they're buying from the market. And you might look at that dip at the very end and go, what's that about? Well, that's actually, they had to take a large nuclear power plant offline for a temporary refueling. That's perfectly normal. And I want to kind of emphasize to you, we are not trying to say that the company should always be above the 100%. You know, we recognize that sometimes you're going to dip below, but a prudent utility is trying to get above 100%, right? That's the critical difference here. We didn't bring this same argument for Evergy West, even though they dipped below 100% at one point, because we recognized they were trying to be above 100%. So how does Evergy Metro stack up against that? I'm sorry, Evergy West. Need to be a bit careful here. Evergy West, as you can see, is well below the line. And this, by the way, is for the prudence period in question that we're talking about, June 21 through November 22nd. Sorry, June of 2021 through November of 2022. And what you can see is that Evergy West is, at best, on average, selling about 60% of the energy that it's buying. The other 40% is uncovered. It's uninsured, to use that analogy that I was describing earlier. And that right there, that's the primary problem. And I'm going to sidetrack here for just a moment, because I'm sure some of the commissioners are aware that Evergy West just acquired shares in a generating facility called Dogwood. Now, we worked with the company when they came in for that to try and settle that case, and we did reach a settlement, and I'm glad we did, because they need the energy. We're happy about that. But I want to emphasize the problem here by showing you this is what happens when you add Dogwood to that equation. We went back and we said, what would it look like if Dogwood had been owned over that period? It doesn't move the needle that much. So again, I'm happy that we worked with Evergy West to acquire Dogwood. I'm glad they acquired it, but it's not a silver bullet to the solution. Like, we are still talking about a pretty big gap. And I also want you to know that this is not, a temporary thing. This is actually a long-standing problem that we've been dealing with here. Evergy West has not been able to cover its load, what it's buying with what it's selling, since around 2008 when it was acquired by Evergy.
Mr. Kleiser, I'm sorry to interrupt. I think we have a question from the bench.
Oh, of course.
Commissioner?
Sorry.
No, please.
Let's go back one slide. And this is why. What is the average between the two? What would happen if you averaged those two out? Or is that not, because it's all Evergy?
So I'm going to say that I personally, sitting right here, right now, have not done that math, but
Okay.
I will tell you that the best person to ask would that be Lena Mansell, and since we know that question's coming,
Okay.
we can try and use some time today if we have an opportunity to figure out what that number would be.
Okay,
I don't know.
thank you, Judge.
Sorry.
All right, thank you.
At the time Evergy West was first acquired, they were only able to cover about 74% of their load. That number has actually gone down since then. Right now, they, again, only able to cover about 62%. And the reason for that's twofold. Obviously, they've had increased load, and they've also shut down some major coal-fired power plants. And this graph that you're seeing right now, this is a comparison of the costs that have flown through the FAC for the last 4 prudence periods for Evergy Metro and Evergy West. And what you can see in Evergy West is in red. That's because they are incurring costs in each one of those prudence periods. In the last prudence period, the one that we're dealing with right now, those costs were over $300 million. Evergy Metro, on the other hand, is in green, and those are negative. And what that means is that that company is making money in each of these FAC prudence periods because they're selling more into the market than they are buying. They're actually producing positive revenue. And that's what we're trying to get for Evergy West as well. So to summarize, our argument is that Evergy West was imprudent because it did not seek to maintain enough generation to cover what it was buying from the market with what it was selling into the market. And by doing that, it exposed its customers to the price volatility of the energy market, which resulted in extremely high costs being flown through the FAC. Now, one of the weirdest and most interesting parts of this case is the amount to which Evergy's own witnesses have testified effectively in support of our position, although not always in this case. So you're going to hear from 3 Evergy witnesses today. You've already heard that. You're going to hear from Mr. John Reed, who is a consultant that Evergy hired. Evergy also hired Mr. Reed to provide testimony in the Dogwood acquisition case, which I mentioned earlier, right? Now, this is what Mr. Reed had to testify in the Dogwood case. And you can read on the slide, he explains that energy prices in the wholesale market can be volatile and increase the risk of high costs for power purchases to meet load. He also explains how reduction in reliance on spot market prices to meet customer needs increases value to customer through mitigating risk of higher costs. And I would ask you to note That is exactly what the OPC is arguing right now. So on this point, Mr. Reed and the OPC are in complete agreement. The possible reduction in risk that Evergy West has foregone over the past decade is exactly why the OPC is arguing that they have been imprudent. Another witness you're going to hear from today is Ms. Kayla Messamore, Evergy West's Vice President of Strategy and Long-Term Planning. And again, in the Dogwood case, Ms. Messamore provided the testimony that you now see. And again, the OPC completely agrees with what she said in Dogwood. But the point I want to emphasize to you is the part at the end where she states, the company's dependence on the energy market can create risk if it is covering a large portion of customers' needs for the long term. And again, I would remind the Commission that Evergy West has been dependent on the energy market since as far back as 2008. So again, Ms. Messamore's statement here supports the OPC's position in this case. The last Evergy witness you're going to hear from today is Mr. Darren Ives, the Vice President for Evergy's Regulatory Affairs. Now, Mr. Ives' statement comes directly from the current case where he states, market purchases can play an important role in a prudent resource mix, but on their own are not a plan, but rather are akin to playing lotto with customer energy supply. Once again, the OPC agrees with Mr. Ives' statement and points out that playing lotto with customer energy supply is exactly what Evergy West has been and still is doing. And I would hope that upon seeing what the company's own witnesses have to say, you would understand why we're bringing this case and why we think there's been imprudence. Also, I'm going to briefly touch on the prudence standard because it is a very big part of the company's case. Now, there was mentioned at one point that the OPC hasn't identified a single decision. That's not, not true. The decision that we've identified is the ongoing decision to not acquire sufficient generation to cover what they're buying. It's not a single point in time decision like we're going to buy that house or we're going to, sell this car. It is an ongoing decision. But let's talk about hindsight here because that was a very big part of the opening you heard from the company. And the OPC is absolutely not relying on hindsight. And the simple reason for that is because we are only looking at the two things that Evergy knew before the prudence period. The first is that they knew they didn't have enough energy to cover their load. They've known that since 2008. And the second thing is just energy markets are volatile. And we've known that since the markets have existed. The best way I want you to think about hindsight, I honestly would ask you to think about it this way. Imagine for a second that Evergy owned a warehouse, right? Then it had a bunch of stuff stored at that warehouse, but they didn't have an insurance policy on the warehouse. And one day the warehouse burnt down, and your staff came to you and said, look, it was imprudent for the company to not have maintained insurance on that warehouse. Now the company's position, their interpretation of hindsight, they would say, well, you can't say it was imprudent because you only knew it was going to burn down with hindsight. Well, if you accept that logic, it's never imprudent to not own insurance, right? You should just not own insurance because it's prudent, apparently. That's not the standard. The standard is to say, would a reasonable person, knowing how much we had stored at that warehouse, have bought insurance before we knew there was going to be a fire? And the answer is yes. And in our case, the standard is, would a reasonable person, knowing that we can't cover 40% of our load and looking at how volatile the markets are, have bought generation to cover that risk? And the answer is yes. So I'm going to talk about the math behind our imprudence calculation because that's another bit of confusion here. Before I do, I'm going to just touch on some hard numbers to give you an understanding. So there are three numbers to deal with in an FAC that you need to keep in mind. The first is called the net base energy cost, and that is what has been included in base rates to cover the cost of energy. This is the amount that the company would cover even if there was no FAC, all right? That amount for this case, this period, was $300 million. The second number is the actual net energy cost, and that is literally just what the company actually incurred in terms of energy. And that number for this case is about $510 million. And the third number is literally just the difference. That's what's actually collected through the FAC, which is about $200 million. And you have to actually apply a jurisdictional factor and a 95-5 sharing mechanism, so that cuts the number down a little bit. The amount flowing through the FAC for this prudence period is about $193 million. Now, I want you to think about something with regard to that number. 3 years ago, this company experienced a massive winter storm called Winter Storm Uri. You might recall, had a huge impact in Texas. Several people died. Major disaster, right? At that time, this company, because it didn't have enough generation, incurred massive costs that were going to flow through the FAC. Instead, they had to securitize those costs, right? The amount that they securitized was $300 million, roughly. So we're talking about right now an amount that's 2/3 of what we had in Winter Storm Uri for this FAC case without the winter storm. It's just a matter of time before something else goes terribly wrong and you have another huge cost run through. So I know I'm running a little long on time, short on time. So I'm going to speed up a little bit here. The critical question regarding prudency is what would a prudent utility need to pay? And to answer that, you have to say what would a prudent utility have done differently? And the difficult part here, and this is something that you will hear from Evergy, is they're saying, well, you would have to go back and look at, what generation would we have bought, how much would that cost, all these other variables. And there are a lot of variables there. It's a difficult equation. And that's a lot of what staff had to say about the same issue. We at the OPC, we decided to say, is there any source that we can look at to kind of get an idea of what a prudent utility would have done? And we said, let's look at their IRP. So what does Evergy West's IRP say? Well, their IRP, which is, by the way, that's the Integrated Resource Plan, for the record, that is filed every 3 years with an update every year. And in every IRP filing the company has filed since Evergy West was acquired, they have said that the best plan, the one with the lowest net present value, is the one that treats Evergy West and Evergy Metro as a combined utility. And you ask yourself the question, do they actually operate as a combined utility? No, they operate as two separate utilities. So we said, let's go model what would it look like if they had been a combined utility. And when we did that modeling, what we came up with is that Evergy West customers would have paid $164 million less in energy costs if they had been combined. But they would have also paid $78 million more in capital costs. And that, if you think about the insurance, that's basically like your insurance premiums, right? So we recognized there would have been a cost to doing what we said, and we worked that into our case. And by taking those two numbers against each other, we came up with our disallowance. Now, just to give you some perspective on how much our disallowance is, I want to point out that this is what it looks like when you compare it to the aggregate of the costs that have been incurred because of the difference in market buying versus selling over that past 4 prudence periods. As you can see, $87 million is actually not that much. All right, very last thing, and I'm going to wrap up here very quickly. We're going to present to you 2 witnesses. Our first witness is going to be Ms. Lena Mansell. She is going to be presenting our case in chief. Ms. Mansell is a professional engineer, 40 years of experience working for both staff and the OPC. She was heavily involved in the Commission's drafting of the original IRP rules and actually has written a white paper on it. She was also fundamental in developing the Commission's FAC rules and has also written a white paper on that. Both of those are attached to her direct testimony if you want more information. Our second witness is Dr. Jeff Mark, our chief economist. He will be presenting our rebuttal to Evergy witness Mr. John Reed. He has had 15 years of experience working in multiple different private and public settings. He's also been a 5-year instructor at the Michigan State's Institute of Public Utilities Fundamentals course and has provided testimony before a very wide range of interest groups on a wide range of issues. Sorry, I had to rush there at the end. All right, and with that, I will ask if there are any questions.
Madam Chair.
Good morning. Thank you, Judge. Good morning, Mr. Kleiser. I do just want to note that you did say $87 million is not that much. I get in context.
Yes, relatively.
Relatively. I do have a question. So kind of on your chart here, you note the difference in RTO cost, but I don't see a timeline. So I'm curious, between these two filings, what changed in Evergy West generation fleet from here to here? What retirements? Tell me about that.
So first of all, if you see across the bottom, I just want to explain, those are the 4 prudence periods. And someone smarter than me, probably ask Lena, will give you the exact dates on what those prudence periods are, just to kind of help you understand that part of it. The critical difference actually is going to be changes in the energy market. That's going to be your bigger problem here. You know what? I'm afraid that you should ask Lena that, because I don't know off the top of my head exactly what retirements or additions have been made. But your primary reason for you seeing those cost differences along the entire breadth of that is going to be changes in the energy market itself. They're just price fluctuations, I think.
Which would not be unique to Evergy West as participating in SPP, because that would affect every utility in SPP. So it would also potentially impact Liberty. I'm just trying to.
No, you're right. And actually, but that illustrates kind of the point. It also affects Evergy Metro, who participates in the exact same energy market. And what you can see is a relative, when Evergy West is going up, Evergy Metro is going further down. And again, that's because they are selling into the market more than they're buying at the same time Evergy West is buying more than they're selling. So when you have a price increase, corresponding benefit and detriment, depending on where you are. So yeah, it affects both sides, absolutely.
All right, Chair Hahn, thank you. Any other bench questions? Commissioner Holzman?
Judge, Commissioner Holtzman, yes, I have a quick question.
When you're ready, sir.
Thank you, Mr. Kleiser. In your example, you pointed out to Winter Storm Uri as being when the house burned down, analogous to your example. In this period that we're looking at, is your disallowance based solely on the fact that you're saying they don't have the insurance, they're not selling into the market enough, or is your number suggesting that there was volatility and that volatility led to higher costs for the ratepayers through the FAC? Is it solely because they didn't have the insurance, or is it because you're saying the warehouse burned down during this period of time?
Okay, there's a couple of different things I need to unpack there to make sure I get a complete answer. And first, I want to make sure this is clear. The prudence period we're talking about does not include Winter Storm Uri costs. That was an example of what had happened in the past. I want to make sure it's perfectly clear that we all understand Winter Storm Uri costs are not being flown through this prudence period. All right, now, that out of the way, I think that the best answer to give you is this. Evergy West has been imprudent continuously for failing to have sufficient generation to cover its costs. But we have not had a significant harm impact until this prudent period, because that was the first time you saw that price volatility increase the costs that are being flown through the FAC so dramatically. So if you understand what I'm trying to say, they were imprudent long before this because they had made a poor decision, but the actual harm hadn't occurred until the house burnt down, metaphorically, until this prudence period when the price volatility caused that impact. And by the way, this is an artifact of the Commission's two-pronged test that you heard discussed during Evergy's case. The idea that you have an imprudence and you have to have the harm associated with it. Part of the problem here is that harm doesn't always happen right after you've made the decision. Sometimes there's a big delay. And that's what makes this so difficult. You say we don't want to have hindsight analysis, but then you get trapped in this situation where you're having to look at this well after the decision was made, because that's when the harm actually occurred. I'm sorry, I'm pontificating here. Did I answer your question?
Sort of. So are you saying the harm did occur during this period of time of the FAC? You're
Yes.
saying that.
Yes.
What is the delta of cost? Is that your disallowance between what you're saying the harm occurred and what it would have not occurred had they been selling in? I'm trying to understand what that volatility impact was.
Right. So calculating the amount of the harm, and that is a difficult question. What the OPC did, and I'll reiterate here very shortly, is we said, what if they had been combined with Evergy Metro? And our $86 million is how much less Evergy West customers would have paid if they had been combined. That was our best proxy, looking at the IRP, looking at the information we had available to try and come up with what a prudent utility would look like. So that $86 million does reflect what we believe the harm that was imposed on customers is. Does that answer your question?
But is that because of volatility, or is that because you believe that that cost would have been saved had they sold more into the market?
I believe the answer is both. I mean, it's both parts of this. They,
So I'm basically saying the volatility during this time period, was it significant enough? And I understand the premise that they could have hedged against it, but the actual volatility, the actual harm, because they didn't hedge, what percentage does that make up the disallowance that you're requesting?
I guess I would say all of it. I mean, I'm not entirely sure if those two things can
Okay.
be distinguished. I would invite you to ask that.
I may follow up with other witnesses. Thank you.
That's
Thank you.
probably
Judge,
your
I have
best
no
answer.
question.
I apologize for not being able to be clearer.
Chair Hahn? All right, thank you. I'm sorry, Chair Hahn?
I have a follow-up question. Is there a chart or any kind of materials in your testimony, or maybe you just know the answer of, earlier you talked about, there's not enough generation to meet load, basically. Do you have a chart by year of, load and generation?
If you'll let me phone a friend really quick. Lena, did you have an actual chart in your testimony?
I looked and I couldn't find one, but I'm looking, I could have overlooked it.
I'm sorry, I don't think that we have that as a chart form.
Or even the information at some point during the case would be nice.
Noted. We'll try and work on that.
All right, thank you. Any further bench questions for public counsel? All right, Mr. Kleiser, thank you. Anything further before we proceed to our first witness?
Since I went to the trouble of printing it off, I would offer that PowerPoint presentation as a demonstrative with no evidentiary weight. It's entirely up to the commission's decision, but I thought to offer it since I printed them.
That's fine, and I don't know, I don't want to mess up any of your numbering, Mr. Kleiser. Would this be exhibit number 300?
It would be 304.
304, thank you. So 304 has been offered for demonstrative purposes. Any objections?
Judge, I'm sorry, just for clarity, was that a demonstrative offer with no evidentiary weight?
Yes, that was mine.
If that's the case, then no objection.
All right, thank you. Exhibit 304 is admitted. Anything further before we proceed to Ms. Messamore? All right, Ms. Messamore, if you'll come forward to be sworn, please. If you'll raise your right hand to be sworn, please. Do you swear the evidence you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you very much. Please have a seat. And Ms. Whipple or Mr. Steiner, whenever you're ready. Thank you.
Please state your name for the record.
Kayla Messmore,
By whom are you employed?
Evergy,
What is your position?
Vice President, Strategy and Long-Term Planning.
In this case, did you prepare direct, rebuttal, and surrebuttal testimony on behalf of Evergy, Missouri West, which have been marked as Exhibits 2, 6, 9, and 10?
Yes.
Do you have any corrections to your direct, rebuttal, or surrebuttal testimony?
I do not.
If I were to ask you the questions contained in those testimonies, would your answers be the same as already set forth in Exhibits 2, 6, 9, and 10?
Yes.
Are those answers true and correct to the best of your knowledge and belief?
Yes.
At this time, Your Honor, we would move to admit Exhibits 2, 6, 9, and 10.
First, I don't mind whatever numbering system we used. I thought in a previous order we had assigned Evergy's numbers, and maybe I'm getting it wrong. I had 100, but was it 1 through 100? 1 through 100?
I think so, Judge.
Okay, very good. Then that's my mistake. I apologize. So I'm sorry, Ms. Whipple, could you go through the numbers again, please?
2, 6, 9, and 10.
2, 6, 9, and 10. Any objections?
Judge, this is not an objection really, it's just more of a clarification. If she had direct rebuttal and surrebuttal, how do we have 4 exhibits?
9 and 10 are for the public and the confidential versions of the SIR rebuttal.
I think that's contrary to the order of how you were to number exhibits, but that's okay with me if you're wanting to go with that.
Yeah, I have no preference as long as we're clear what's confidential and what's public. That's perfectly fine. So I have offered exhibits 2, 6, 9, and 10. Any objections? Okay, hearing none, exhibits 2, 6, 9, and 10 are admitted.
Thank you, and we tender the witness for cross.
Ms. Whipple, thank you. Any questions from staff?
No, Judge, thanks.
Mr. Keeble, thank you. Cross from Public Counsel.
Yes. I'm actually going to ask to start by marking an exhibit, which would be 305.
Very good. Thank you. Thank you. This is 305. Thank you.
Oh, good morning, Ms. Messamore.
Good morning.
I actually just want to start by, for the sake of the record, making sure I had some definitions that worked, and I felt like this was a neutral source that we might be able to agree on some meaning of some terms. This is a energy primer for a handbook for energy market braces put out by the Federal Energy Regulatory Commission. Would you agree with me?
That's what it looks like.
Apologies, going to have to interrupt here, Judge. To the extent that we are going to have this offered into evidence and elicit witness testimony as to it, I think at least we need some foundation laid. Authenticity would be required.
No, I will leave that to Mr. Kleiser.
I'd like to proceed with just having a discussion and see if she agrees with the definitions. And honestly, it's not really as much as offering this as, again, making sure that the record is clear as how capacity and energy are being used for the sake of, establishing that and making it easier to brief. So if you could turn to me the first kind of attached page, which I didn't put the entire thing in, it's a rather large document. And, the quick facts section there, we talked about measuring electricity. Can you just read that box to yourself? You don't have to read it out loud.
Okay.
Would you significantly disagree with the definitions kind of laid out in there and describing what capacity, demand, and energy are?
I don't see where it defines demand or energy. Or I see energy and I see capacity.
Oh, sure. I'll show you the very last sentence. The amount of power consumed at any location is the demand at that point.
Okay, yeah, I see that.
Would you agree with me that that's a fairly accurate recitation of the terms capacity, demand, and energy, or how they're calculated and used in our regulatory environment?
I would say one difference is this is more of a nameplate description of capacity as opposed to a view of accredited capacity, which is what we typically focus on. But in terms of how these measures of energy work, yeah, I think they are correct.
And again, I'm literally just wanting to make sure that the record is easy here. So what is accredited capacity and how is that different so that, things are clear?
Accredited capacity is established under the resource adequacy requirements that SPP creates in our case. And so those are defined to say, based on the nameplate capacity, what is the percentage of that nameplate that is effective in meeting customer load requirements?
Thank you. We can go through and kind of read out what each of these things are and kind of establish what capacity and demand are. Again, I was just doing this for the sake of my record. Or I can move to admit it as is. It depends on whether you intend to lodge an objection.
At this time, I think we would have to object to its admission If you want to ask the witness what you think definitions may or may not be for various terms, you can explore that, but I don't think you can use this document as evidence.
Sure, okay. Would you agree with me, Ms. Messamore, that the amount of electricity or energy generated or transmitted is going to be measured and used over time is going to be measured in watt hours?
We don't usually measure in watt hours, but megawatt hours, kilowatt hours, sure.
Sure. And that the amount of energy per unit of time generated, the unit of electricity is watts. We can agree with that?
Sure,
And that's a measure of energy.
sure.
And so the amount of electricity a generator can produce in an hour is its capacity.
Its capacity is its physical capability to produce energy.
That works. All right. I won't even offer it. I just wanted to have some definitions of the record. I apologize for that taking so long. I'm actually going to move on to the real course of my cross, which should hopefully take not that much time. But I'm going to ask to mark another exhibit. This would be Exhibit 306. Oh dear. Do you have the one I marked up with a highlighter?
I don't know, but you can find out. If you want to give me that version, that'd be fine.
Sorry about that. Ms. Messamore, can you identify this document?
Judging based on what I remember, I think this is direct in the Dogwood CCN case. Do not remember all case numbers perfectly.
And you would agree with me that this was your direct testimony offered in the Dogwood CCN case, correct?
Seems to be.
Now, this is the confidential version. I will not be attempting to touch on any confidential material. If, for whatever reason, we require to, please signal that to the judge so that we can pause. But my intention is to refrain from discussing confidential information. You were a participant in the Dogwood case on behalf of Evergy West, correct?
Yes, that's
And
why I
you
filed
did-
testimony.
So you did, in fact, file direct testimony?
Yes.
Can you turn to page 11 of this testimony?
Okay.
And beginning on page 11, line 13, you would agree with me that the question was posed to you, does EMW have an energy need? Is that accurate?
Yes.
And EMW, for the record, is referring again to Evergy, Missouri West, correct?
Correct.
And your response reads, yes, capacity is essentially the ability to produce energy when called upon. Therefore, anytime a market participant is short on capacity, it is also short on energy capability. As a result, the forecasted reserve balances in the 2023 IRP is an indication of the current and ongoing energy need for EMW customers. In addition, market capacity, like the capacity EMW purchases from Evergy Metro, only includes mutually agreed upon market energy, or no energy at all, which doesn't provide a long-term energy hedge. As a result, the amount of capacity currently covered by these market capacity contract purchases, in parentheses 240 megawatts in 2026, end of parentheses, represents an incremental need for energy available on the EMW system to meet customer needs. This need for energy can and has been met by the wholesale energy market, but this dependence on the energy market can create risk if it is covering a large portion of customer needs for the long term. Would you agree with me that, but for my flubs, I read that primarily correct?
Yes.
And you would agree with me that beginning on page 12 at line 4, you were asked a question. In prior testimony, staff implies that there is not a need for energy, but rather a need for a hedge against market energy prices. Do you agree with this perspective?
Yes, that's what it says.
And you would agree with me that at least the first line of your response reads, no, these two needs are not mutually exclusive, and ENW has a need for both. Is that correct?
That's what it says.
And beginning at line 12, you would agree with me that it reads, as I described above, in the past, ENW has been able to use market capacity to meet its capacity needs, and it has relied on the wholesale market to provide sufficient physical energy. You would agree with me that's what that says?
Yes.
And if I turn to page 13, beginning at line 6, you would agree that it reads, in addition, a strategy of relying on wholesale capacity and energy does not provide a hedge for ENW to mitigate its exposure to energy prices. As I will describe in more detail later in this testimony, a large portion of ENW capacity consists of inefficient, high heat rate natural gas turbines which operate very infrequently, as company witness Carlson explains. ENW leans on the more economic wholesale market to provide energy when these units aren't dispatched due to being out of the money. Effectively, this results in ENW being a price taker for any time the wholesale market is cheaper than the operating cost of its natural gas turbines, which is a significant portion of the time. You would agree with me that that's what that reads?
Yes.
And you would agree with me at line 18, it reads, in the very same way, some of ENW's market capacity contracts also make it a price taker because those contracts do not include corresponding energy. The capacity contracts that do not include an energy option are only set at mutually agreeable market prices at the time of the transaction. That is the need for an energy hedge, which staff references and which is very real for ENW customers. You'd agree with me that's what that says?
No, it's the capacity contracts that do include an energy option are only set at mutually agreeable market prices at the time of the transaction, or of transaction.
I apologize. Thank you for correcting my misread. But otherwise, you'd agree with me that that's what that says?
Yes.
I'm going to break this one down a little bit slower, but beginning on page 14, there was a question, what does it mean to need a hedge? You would agree with me?
Yes.
And your answer, a need for a hedge simply means that you do not have sufficient control or certainty around your future outcomes based on your specific risk tolerance, and so you want to find some way to improve that control/certainty. As company witness Reed describes, insurance is an example of a hedge in that it does come with a cost, parentheses, insurance premium, and parentheses, but the purpose is to give you greater stability and security in your future costs. In general, if you do not end up using your health insurance, parentheses, e.g., because you did not have any major medical issues, end parentheses, you are better off overall. Would it have been nice to know that you were not going to use the insurance so you could save yourself paying on the premium costs? Yes. Would it have been possible for you to know that in advance? No. If something serious had happened, would you have been very glad you had insurance? Yes. Is that accurate?
Yes.
All right, so let me understand this with regard to insurance. It appears that you are arguing that it's prudent to have insurance even though you don't know that a major event is going to come and even though it might cost you money. Is that an accurate interpretation of what you're trying to say there?
I think I have my response to that question in my written testimony, which is essentially how much insurance you purchase is dependent on the range of volatility that you expect, the cost of the insurance, the effectiveness of the insurance, and mitigating that risk. All of that is what we look at in an IRP process. Sorry to mix metaphors or to lose the metaphor there at the end.
All right, let's answer just a couple of quick questions though. Is it still prudent to buy insurance even if the insurance ends up costing you money because you don't make a claim, for example?
Depends on what you're insuring against and how much the insurance costs.
All right. I'm going to pick up here then at line 13. In the same way, an energy hedge provides you greater energy cost stability and security in an inherently uncertain future. At times, a hedge can be a specific financial or physical transaction to try and offset your future risk on a particular commodity. However, it can also simply be a strategy of not putting all eggs in one basket, or in more technical terms, maintaining a diverse fleet of resources so that you are not overly exposed to the price or availability of any single fuel energy source. Figure 2 below shows that while EMW does have a relatively diverse mix of fuels in its portfolio, approximately 70% of its forecasted capacity in 2026 is coming from the market or peaking capacity. That means that EMW is essentially a price taker for 70% of its energy, and that is why it has a need for a hedge, a generator which will produce economic energy to offset EMW's exposure to the SPP energy market, in addition to the needs for physical capacity and energy that it also has. Is that accurate?
Yes, can I keep reading the paragraph? Which is hedges should not be purchased at any cost, e.g. a coal plant can provide a hedge, but depending on its fixed and variable cost, it could be too costly to justify its hedge value, but instead should be evaluated based on its all-in cost and the long-term benefits it provides in terms of physical capacity, energy, and hedge value.
Certainly. Thank you.
Thank you.
All right, at this time, Your Honor, I would move to admit 306. That would be the direct testimony of Kayla Messamore in case EA 2023-0291.
Mr. Kleiser, thank you. 306 has been offered. Any objections? Hearing none, exhibit three. I'm sorry,
Yes,
go
Your Honor, I
ahead.
was just waiting for staff to have a chance. We would object that it is entirely irrelevant. In fact, it was filed well after the audit period at issue, and it's a separate proceeding as well.
All right. Objection is noted. Objection is overruled, and exhibit 306 is admitted. Mr. Kleiser?
It is confidential, Judge.
I apologize. He is accurate. It is confidential and should be marked as such.
We'll mark it as 306C. Thank you.
I would... No, it's not worth it. I think I have no further questions at this time. Thank you.
Mr. Kleiser, thank you. Let me see if we have any bench questions. Chair Hahn. Great, thank you. Commissioner Coleman? No. Thank you. Commissioner
Yes.
Holzman? Commissioner Holzman?
Yes, for clarification, in Mr. Kleiser's analogy of insurance premiums, insurance in this case would be investment in increased capacity, correct? New production or new generation?
I don't really want to speak for OPC on what they mean by insurance, but I think insurance, from my perspective, can be a variety of different things, whether it's different contracts or actual physical or financial hedges. But yes, it could include adding additional resources.
Okay, but at the end of the day, OPC's argument from your perspective is that you don't have enough generating capacity to sell into the RTO. Would you agree that that's the argument they're making?
I think OPC is shaking their head at me. So I will say I think OPC is arguing more around actual net position in the energy market as opposed to capacity.
Okay, thank
Yes,
you.
they
Thank you, Judge.
they are related concepts.
I apologize, Judge. That was not an attempt to influence the witness.
Right. Commissioner Holzman, thank you. Any further bench questions? Commissioner Kolkmeyer? Commissioner Mitchell?
Yes, I have one, and it's just to help me understand a little bit more about the integrated resource planning process. I think both the company and OPC mentioned that integrated resource planning was done before the acquisition of Evergy West, or at some point early in the acquisition of Evergy West, and then that resource plan is updated periodically. And how frequently is it
Yeah,
plan
so
updated?
we file full compliance filings every 3 years, but then we make annual updates every year in between.
And is that integrated resource plan, a combined look at Metro and West?
No, it's not. When we file an integrated resource plan, we're selecting a preferred plan for the individual utility, so Missouri West in this case, and that's based on analysis specific to Missouri West. OPC has talked about how we run joint plans. Those are informational only to view what do different plans look like if the resources were combined, but that doesn't result in the selection of the preferred plan.
Thank you, that helps me.
Commissioner, thank you. I think I have, if there are no further commissioner questions, I think I have, Ms. Messmore, just a couple of questions and you can refer to your testimony if you need to, on page 17 of your direct. I believe you state that Evergy would be willing to discuss with public counsel and other stakeholders combining Metro and West in the future. If that's true, how would that discussion start? Would it start in a rate case or another case, or do you have any perspective on that?
I think Mr. Ives can speak to the history on this more detail, but I would say those discussions have somewhat already started. We filed a report before the commission a few years ago around the process and what it would look like to consolidate. So I would say it's kind of already started, but he can speak more to the history there.
Okay, thank you. Ms. Mantle has filed some rebuttal and that quotes from your direct, and I believe that was just admitted as Exhibit 306, your direct in EO 2023-0291. And I think, let me double check on pages 14 and 15. Let me make sure I get that reference right.
14 and 15 in my testimony or Ms. Mantle's?
Yeah, on yours, yes, thank you. And I believe more on page 15. Your testimony in that case states that hedges should not be purchased at any cost. For example, a coal plant can provide a hedge, but depending on its fixed and variable costs, it could be too costly to justify its hedge value. But instead should be evaluated based on its all-in costs and the long-term benefits it provides in terms of physical capacity, energy, and hedge value. Would this evaluation also apply to long-term PPAs, and if not, please explain why?
Yes, it would. We evaluate PPAs and actual owned capacity in the IRP in the same way. So if we're looking at a long-term capacity PPA, we put that in as a capacity resource that doesn't include any energy revenue offset. So you can see the net impact under a large variety of market price scenarios of purchasing that energy from the market.
All right, thank you. I think those are all the questions I have. Any further bench questions before we go to recross? All right, seeing none. Any recross based on bench questions? Mr. Keevil.
Very briefly, and just follow up on the judge's last question. What is your understanding regarding public counsel's proposal in this case as concerned market energy prices and long-term PPA prices? Are we talking about the same thing there, or is one bid in like on a daily basis, one's long-term basis? What's the difference there, or is there a difference?
If I can ask a clarification, are you talking long-term PPAs like a wind PPA, for example, or more of a long-term capacity PPA?
Well, as you were using it there in your reference on, in your, what's been marked Exhibit 306.
Okay. Trying to think. Sorry, can you ask the question one more time to make sure I answer it?
Well, I'm just wanting to make sure we're not getting apples and oranges necessarily confused here. Is this issue, as you see it in this case, about long-term PPA prices, or are we talking about like daily energy prices, or more of a I heard volatility discussed quite a bit in the opening statements, and the long-term PPAs wouldn't necessarily be volatile to the extent that market energy prices would be, would they?
That's correct. So there's a bifurcation between we'll call it the cost of the resources that you're adding, which could be long-term PPAs to meet capacity requirements, and then the actual results in the energy market. So if you think back to the bench questions around the charts during the opening statement, you saw that increase between review periods, which was driven primarily by natural gas price increases between those two review periods. And so that created an increase in wholesale market prices. It also created an increase in the cost of fuel for any natural gas-fired resource, which would impact any of those that were actually dispatched. So there's kind of multiple parts, but they are distinct, where there's how are you planning around the all-in cost of all resources, and how do they perform in different energy markets, and then what actually happens in the energy market in the dispatch.
Okay, thank you. Nothing further.
Mr. Keevil, thank you. Recross.
Judge,
Yeah, I'm sorry, Commissioner?
just Commissioner Holden, I do have one more question that occurred to me. It's all right if I ask.
When you're ready, sir.
Okay, thank you. Where does Evergy West sit in terms of SPP's resource adequacy requirements? Would you categorize Evergy West as being adequate generation, or above or below the resource adequacy requirement of SPP?
Yeah, they are, so during this review period, they were above the reserve margin, so they were meeting the 12% reserve margin during this period, and at this point, they are above the 15% reserve margin for this summer.
Okay. Thank you very much. Thank you, Judge.
Commissioner, thank you. Let me, Mr. Keevil, any cross based on Commissioner Holzman's questions?
No, thank you, Judge.
All right, Mr. Keevil, thank you. Recross, Mr. Kleiser.
Yeah, so let's start with the questions that have been posed to you now by Commissioner Holzman, and try and have a better understanding of capacity and energy and how those interplay, because I feel like there might be some confusion brewing here. So we talked at the very beginning sort of some definitions. Do you recall that?
Yes.
All right, so when he's asking you about capacity, capacity represents the total amount of energy that a generator can't produce. And we can have nameplate or we can have accredited, and there's distinctions obviously, but that's effectively what we're talking about, the amount of energy it can produce. Is that accurate?
Commissioner Holzman's question was would have specifically related to accredited capacity.
All right, I'll try and keep it to just accredited capacity, that's fine. But you would agree with me then that it's reflecting what the SPP energy market accredits as the amount of a generator can produce?
No.
Okay.
One, it's not in the energy market, it's a separate process. And two, accreditation is a measure of how well the resource is expected to be able to meet energy needs. So it's a discount to its physical capability based on its expected actual capability.
Okay. SPP imposes on each of its utilities, including Evergy West, a requirement to maintain a certain amount of capacity, correct?
Accredited capacity, yes.
Correct. And that's the capacity requirement that Commissioner Holzman was referring to. Is that accurate?
Yes.
And I'm going to screw this up here, so you'll probably correct me. That is equal to the peak load plus a reserve margin?
That is the capacity requirement, yes.
Oh, it is. I got it right. And Evergy West is meeting that, as you said, correct?
Yes, and was during this review period.
Absolutely. And in meeting that, Evergy West is utilizing a capacity contract with its sister company, Evergy Metro, correct?
That is part of the resource plan, yes.
Yes, and according to the direct testimony that we already discussed, that capacity contract does not supply actual energy for Evergy West, correct?
The reason the capacity contract is able to count as firm capacity for Missouri West is because Metro's resources are fully deliverable to the Evergy Missouri West load. So there is physical energy assumed to be available under that contract. If there wasn't, it wouldn't count as firm capacity.
I agree with everything you're saying, but the question is that contract supplying energy that Evergy West is permitted to sell into the RTO energy market to produce revenues?
No, I don't think that's how the contract would work.
Correct. And so to get to the finer point, which is kind of the first questions you were asked, the OPC's concern here is with Evergy West not selling energy into the market, not with the capacity requirement being met. Would you say that's accurate?
I don't want to speak for you.
Fair enough. We'll just have to address that in briefing, I suppose. I have no further cross. Thank you.
Mr. Kleiser, thank you. Redirect? Ms. Whipple, when you're ready.
Yes, thank you. Ms. Messamore, in responding to questions from Commissioner Mitchell, you discussed EMW's planning process. In prior resource planning decisions, has EMW looked at adding generation in selecting its preferred plan in past years?
Yes, all of the IRPs that we've done recently, as far back as I can have reviewed, include plans that would add additional generation as an alternative to what was ultimately selected.
And why was adding generation not selected in prior years' plans?
Because the cost of adding the generation didn't justify the benefits.
You were also asked about, I think from the bench as well as Mr. Kleiser, about your dogwood testimony. Now, this was filed in 2023. Can you explain the relationship between the dogwood matter and, you know, why is EMW looking at adding dogwood now in 2023 as opposed to earlier?
Yeah, the primary change is that SPP has increased the resource adequacy requirements for all members. And so that first manifested in an increase in the reserve margin for summer 2023. It went from 12% to 15%, which increased Missouri West's need for accredited capacity. And dogwood primarily is to fill that need.
In some of your responses where parts of your testimony read, you noted that not all of it was being read. Was there anything that you thought you should add to provide the context necessary for your response regarding dogwood?
I think I read the most important part, which is about the cost trade-off between a hedge and the value that it provides. I would say the other portion that is relevant is dogwood is focused on the need that existed in 2024 because of the increase in the reserve margin and the expected continued increases in resource adequacy requirements going forward. So it was not looking at a need that existed during this review period.
So in this case, there's been lots of competing allusions to insurance and how that may or may be an appropriate analogy to Prudence in this case. Do you think there's a good analogy for insurance here in this case or not?
I think that insurance is a fine analogy. It's being used poorly. So I would think about insurance here is when we look at the IRP, when we model a resource plan, we're saying what's the range of potential futures that we're concerned about, and then we run a lot of different resource plans, so a lot of different combinations of insurance or types of insurance, to use the analogy. We see how well do those perform against each other in a wide variety of scenarios. So that's intended to assess what's the level of volatility or the risk created by the range of uncertainty, what's the cost of the insurance, so the different resources, and then how well do they mitigate the cost or the impact of that risk. All of that shows up in the net present value of revenue requirement, which we use to assess different resource plans and to compare them against each other.
Are you aware if OPC has or has not conducted that wholesome evaluation when it's discussing a hedge?
No, they seem to have only compared to a hypothetical average
I'm
of
going to
Missouri.
object that her answer appears to be speculative.
It is not, Your Honor. It's asking
She
for
literally
knowledge.
said, I'm sorry.
I'm sorry, Ms. Whipple?
I'm not requesting the witness's speculation. I'm requesting her knowledge.
No.
Your Honor,
Go ahead.
she literally starts with "it appears."
I understand. I'll overrule the objection.
And I will reword the response to say I see no actual analysis of what that risk assessment would look like. I see only a comparison of Missouri West's actual cost to a hypothetical average of Missouri West and Metro.
And what would be the issue with that?
It has nothing to do with the proposed the alleged imprudence, which is around the actual need to procure generation or a perceived need to procure generation. They're comparing to an average number that doesn't have anything to do with that.
Okay. Thank you. No further questions.
Right, Ms. Whipple, thank you. Ms. Messmore, thank you very much. You may be excused. This looks to be a good time to take a mid-morning break. I'm showing the time to be roughly 10:23, so let's take a break until 10:38. We'll give you 15 minutes. Anything, excuse me, anything from council or the bench before we take a break? All right, thank you. We're off the record. back on the record, I show the time to be 10:40, so we took a little bit of an extended break. Is there anything from council or from the bench before we proceed to Mr. Reed from the company?
Yes, Judge. May Ms. Messamore be finally dismissed?
Any objections? That she is dismissed. Thank you.
Great, thank you.
Thank you
No
so
other
much.
issues.
Thank you. All right, well, Mr. Reed, come forward to be sworn, please. All right, if you'll raise your right hand to be sworn, please. You swear the evidence you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you, sir. You may have a seat. And Mr. Steiner, when you're ready, sir.
Please state your name for the record.
My name is John J. Reed.
Mr. Reed, where do you work and what's your position there?
I am chairman of Concentric Energy Advisors.
Did you cause to be filed in this case direct rebuttal and surrebuttal testimony, which have been previously marked as Exhibits 3, 7, and 11?
I did.
Do you have any changes or corrections to that testimony?
No, I do not.
Are your answers contained in that testimony true and accurate to the best of your knowledge?
Yes, they are.
Your Honor, at this time I would offer Exhibits 3, 7, and 11.
Any objections? Hearing none, Exhibits 3, 7, and 11 are admitted.
Attend to the witness for cross.
All right, Mr. Steiner, thank you. Any cross-examination from staff? Mr. Keevil?
No, Judge.
Mr. Kleiser?
Not at this time, Your Honor. Thank you.
All right, thank you. Any bench questions for Mr. Reed? Going once, going twice. All right. Mr. Reed, thank you. You may step down.
Okay.
Your Honor, like the first witness, could we ask that Mr. Reed be dismissed?
Any objections? All right. Mr. Reed, you are excused. Thank you. Your next witness?
Call Darren Ives.
Mr. Ives, if you'll come forward to be sworn, please. If you'll raise your right hand to be sworn, do you swear the evidence you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you, sir. You may have a seat. And Counsel Officer Ms. Whipple, when you're ready.
Please state your name.
My name is Darren Ives.
By whom are you employed?
I'm employed by Evergy.
And what is your position?
I'm the Vice President of Regulatory Affairs.
In this case, did you prepare direct, rebuttal, and surrebuttal testimony on behalf of Evergy, Missouri West, which has been marked as Exhibits 1, 5, and 8?
I did.
Do you have any corrections to your direct, rebuttal, or surrebuttal testimony?
None that I'm aware of.
If I were to ask you the same questions presented in those testimonies, would your answers be as also set forth in Exhibits 1, 5, and 8?
Yes, they would.
Are those answers true and correct to the best of your knowledge and belief?
Yes, they are.
Judge, at this time, would move to admit Exhibits 1, 5, and 8, please.
Any objections? Right. Exhibits 1, 5, and 8 are admitted into evidence.
Thank you. Tender the witness for cross.
Ms. Whipple, thank you. Any cross from staff? Mr. Keevil?
Mr. Ives, when you say you are employed by Evergy, which Evergy are we talking about there?
I'm actually employed by Evergy Metro, but I'm an officer for all of the regulated jurisdictions.
Okay, but your employment is with Metro?
Yes,
Okay.
sir.
Thank you. That's all I have, Judge.
Mr. Keevil, thank you. Mr. Kleiser?
No questions at this time. Thank you.
Thank you. Any bench questions? Commissioner Holzman, when you're ready.
Thank you. Good morning.
Good morning, Commissioner.
I want to try to unpack a little bit here, if we can. from the company's perspective, why not build more capacity or more accredited capacity? Why if you're going to get a rate of return on the capital spend, and you're going to create this insurance policy as OPC would define it, and you're going to meet the potentially expanded new resource adequacy requirements that SPP is going to put on you, why are you not constructing new generation?
Yeah, no, it's a good question. We absolutely intend to. If you look at our currently on file integrated resource plan, you'll see that there's quite a host of resource additions, as well as some upcoming retirements that are in the 20-year plan. But if you go back over time, since I've been involved with EMW in the 2007, 2008 timeframe, we looked at our integrated resource plan, we looked at availability of resources, and we built that to advance the least cost resource plan, and having the mix of market utilization that EMW has had has come out as the lowest cost resource plan that we've brought in front of the commission each year. Ms. Messamore talked about it, though. I mean, if you look currently and some of the change in accreditation and some of the change in resource adequacy at SPP, you see more acute need today, and you're starting to see it come out in the resource plan at a more current level. We talked about dogwood earlier. We're bringing that on board. That's a step, a first step. You saw from the chart in the opening, not the silver bullet, not the end game, but an improvement and a step. This commission might remember we brought a currently in place wind resource that we intended to put into EMW to also provide energy. It was called Persimmon Creek. We brought that resource in front of the commission and ultimately got an order in a CCN docket that had some conditions that we deemed to be untenable from a sharing perspective of market cost with our shareholders. So we ended up pulling that out and taking it and applying it as a Kansas resource where we did not receive those conditions. So we've been trying. At this stage where you're at is you're in a market where, existing resources are limited. When you put out RFPs, there's not a lot of people just looking to offload natural gas plants or facilities. So then you get into build, you've got supply chain restrictions and constrictions right now, multiple years to site develop. That's why you see in our IRP some natural gas builds that are out in the 29, 30 timeframe, which means if we start today, we can get the permits, get the siting done, and get the construction completed in that timeframe.
What kind of capacity, Ms. Messamore talked about bifurcating the PPAs from, your internal generation. If you wanted to go out there right now and buy every PPA opportunity available to you, how much capacity do you think exists today that could be entered into an agreement?
From a non-renewable standpoint, I would say it's very limited, particularly in the near-term region. I mean, dogwood was one of the few examples of a dispatchable resource that
How many megawatts was dogwood? Roughly.
It's probably a better question for Ms. Messamore. I want to say, for some reason, I have 300.
I was thinking 300 as well.
In my mind.
Okay, that helps. And that 300 megawatts coming into your existing footprint, what did that do to the insurance before you had it?
Yeah, I probably can't disagree with the chart that was in the demonstrative exhibit at the start. I mean, it is, on the edges. I mean, it gives us a slight erosion of that gap in our supply to our load. But it's a step, and it's one that was readily available, and based on the commission's decision, we were able to close on in the end of April this year. We don't have to wait 5 years for a construction cycle for that.
If you did have renewable PPAs available to you, I understand that the accredited capacity for those resources are much less because they're not baseload, so that they may not move the needle on the resource adequacy targets or requirements that SPP does, but how would they impact what Mr. Kleiser is presenting, which is you don't have enough power to sell in to generate revenue?
Yeah, it certainly helps, right? I mean, anytime you can, bring energy from those resources to bear in the market, and you're at a zero or lower cost of entry for a wind or a solar facility, you're bringing energy in that when it's able to operate is going to be picked up by the market, and be a good hedge or offset. We've looked at those too, right? I mean, when we looked at Persimmon Creek again, we had found a couple of wind options that were existing and one or two solar that were existing, but even those are not as readily available as they used to be. So you start to talk again about construction and either utilizing a developer to do a build transfer, or ultimately doing our own development and getting the land and the resources to do it, which all is going to add years to starting to alleviate this energy gap.
How much is transmission a constriction? So we looked at the congestion maps for some of the renewable assets that are out there, and they get indigo purple because the cost of those are not being able to be delivered to where the demand is. What do you see as transmission plays a role in access to being able to sell into a market where the demand is?
Yeah, it matters, but when you're looking at existing resources, most of them have been cited with an eye towards transmission capabilities and being able to have paths available for those. So it becomes more acute when you're thinking about building or development and kind of that multi-year approach. And even then, you've got companies that are out there and have projects that have gone through the SPP process to be evaluated for transmission capability. So it's an issue, and we've always got to be cognizant. It's certainly one of the factors that we evaluate in all of our RFP approaches. But so far, we've been able to address transmission in the projects we've been looking at.
Okay. Let's talk about the idea of combining West and Metro together. My first question is, do they operate independently of each other in paperwork only, or is there a legitimate operational separation between the two entities?
Well, the short answer to that is yes, a little bit of both. Everywhere that we have the capability to operate jointly and create efficiencies with them, we do so. I'm a great example of that, right? Some people in the room might disagree with that, but I would say I'm a vice president, and I have responsibility for all of our jurisdictional utilities, right? So while they're separate jurisdictions and oftentimes separate legal entities, we have one vice president of regulatory affairs, right?
What's the benefit of having separate jurisdictions? Like, why is that a good thing?
Well, I don't know that I would characterize it as a benefit. I would characterize it as a result of 100 years of history. Mm-hmm. You've gone through in various forms and fashions and had ownership of these different entities. Their customers have paid for and they have built out a system to meet the needs for their area over 100 years, right? Differently for West than Metro did theirs, and bringing those things together and getting customers to agree to kind of blend the cost of bringing them together is difficult. We've done it a couple times. We brought together a couple small jurisdictions that were in the EMW area. It's actually a combination of the old Missouri Public Service, which is more based in the metro Kansas City area, and St. Joe Light and Power, which was up north. Between Aquila and us, those entities were separate once they were owned by the same company for 15 plus years before we were able to get everything lined up and get our rates and our structures close enough that we could bring them together. We did that through a proceeding in front of this commission. On the Kansas side, the Western Resources, Westar entity, they went through about a 20-year process to align jurisdictional rates between their northern and southern jurisdictions after they got kind of sole ownership of both of those. So there are a number of steps and processes that you have to go through to get things closely enough aligned that then you can start doing rate comparisons and say, now how much is it going to impact a residential customer of Missouri Metro to have the same rates as a residential customer of Missouri West? And oftentimes, even when you get there, you find that you have to go through a phase-in over multiple cases to really bring them together, a gradualism approach so that you don't overwhelm, any particular customer base.
What's the approximate size of Metro versus West? Which one is a larger customer base?
I think Metro's slightly bigger on the Missouri side. They're both pretty equivalent. They're 350,000 customers plus or minus. So pretty similarly situated, but if you think about it, they're very different jurisdictions. West is more rural, so it's got a lot less density per line mile. West has less supply available historically than Metro has had. So there are a lot of differences in what their respective customers have put in place and paid for that we've got to figure out how to make that look like.
Do you know off the top of your head which one pays a higher rate?
Yeah, so over time, for sure, Metro customers have consistently paid higher overall rates than West, really driven by many years of this resource differential that we're talking about here. When market prices were low, when gas prices were low, not having invested in generation benefited the West customers for a number of years. That's why it kept showing on the integrated resource plans that we filed as the least cost option when we ran our scenarios. In the recent year or so, they're probably much more equivalent because of the higher fuel costs that EMW has paid really since the period of Winter Storm Uri. We had a follow-on winter storm. We had some, high periods of natural gas post-Winter Storm Uri that have put pressure on that for West.
So Ms. Messmore testified that currently West is able to borrow some of Metro's accredited capacity to meet its resource adequacy requirement with SPP. That's correct?
That is correct.
And is there a benefit to the ratepayers of West to be able to do that because they're not having to invest in accredited capacity?
It is cost effective from a capacity standpoint. Probably should close the loop on that and say, we plan both West and Metro on standalone integrated resource plan basis. We put an overlay on top of that that shows what a combined view is, but that's not how we actually implement our integrated resource plans or what we rely upon in our IRP filing. That said, when we can competitively bid capacity, which we do bid out capacity, and Metro competes with other third parties, and that price comes in well below the cost of an infrastructure investment for that capacity.
So, Mr. Kleiser, in his opening, essentially made the point that Evergy Metro's capacity is such, or your generation is such that you can sell into the SPP, and there's a positive revenue stream that's created because you have excess capacity. Conversely, West, that does not have the necessary capacity to hedge the volatility, is, on the graph it was at 60 or 70% and not hitting the 100%. If the two were combined, would the amount of generation still exist to create positive revenue for excess capacity to sell into the market if you were taking into consideration West's deficit?
I think that's similar to the question that Chair Hahn asked early on. I would say it's getting close to a push. If you look at our currently filed integrated resource plan and some of the changes that are going on in SPP, you see that we've got some capacity needs, even coming up in Metro. And when you have capacity needs, you're ultimately going to have energy needs. And I think it's fair to say that even at Metro, they have had the opportunity to make some sales into the market and have some good wholesale experience. Those opportunities are really different depending on the market. When natural gas is really low, that has a very different impact on the ability for our coal to go into market than when natural gas is high. The same is true on renewables. When renewables aren't operating, there's more opportunity for our dispatchable resources to get in. When the wind's blowing and the sun is shining well, there's less opportunity for our coal units and dispatchable resources to get into the market.
Would there be an access to capital benefit if West and Metro were combined together?
Absolutely. Both of them, getting scale helps access to capital. It helps you put larger placements into the market for debt. It helps you think about having more opportunities to balance your capital structure. The flip side of that is we have existing debt today in both entities, but I'll talk about Metro, that is served by the assets at Metro. Those assets are serving Kansas and Missouri customers in Metro today. We probably have to unwind that secured debt if we move for a combination between Metro and West from a legal entity standpoint, which could result in new debt at currently higher interest cost and could result in make-whole payments for debt that we're trying to get out from under. So it's never as simple as it seems by just combining. There'd be a number of steps in that progression.
So which entity's rate base ultimately will pay back the securitization for the $300 million from Uri?
West customers are paying for that.
Okay. If you made the determination that it was in the best interest of the company and the ratepayers to unify the two sides, realistically, at breakneck speed, how quickly could it be accomplished?
I've asked myself that question for at least 5 or more years now, probably.
What would it require? Would it require action by this commission, action by the Kansas Commission? Would FERC need to be involved since it crossed state lines?
Yeah, I think likely both. And the difficult step in the process from my perspective and where I've grappled with it is, what do we do with Metro? The fact that the generation at Metro serves both Kansas and Missouri customers. So, you would think if that generation just served Missouri Metro, combining them would be, a huge benefit, right? West is looking for energy and capacity. Metro has some, a better stack available today, but how does Kansas get compensated for that? Because their customers have paid for that generation to come in over the last 50 or 100 years. and how do they ensure, as we go through that process, that their customers get treated fairly? So it's not just that both have to do it, we probably have to go through it together with both of them, so we don't end up getting different answers that leave a bunch of dollars stranded to our shareholders to cover because the states took different positions in separating it out.
1, 3, 5 years, 10 years?
Over 5 for sure. I'd
Over
say
5 years.
closer to 10. I was gonna get really specific and say 9, but that's probably too specific.
So combining them would be a endeavor that would extend beyond new generation if you were going to build it. You said 2029 would be target the IRP for natural gas plants. So your quickest route to increased capacity generation for West is either new construction or PPAs at this juncture.
Yes, I mean, from our perspective, it's outlined in our recently filed IRP, right? Our ability to make some inroads with some additional renewable resources, both from a wind and a solar standpoint, and get started on natural gas construction. You know, and I would add, we're talking about Missouri West today. We show we need natural gas also in our Kansas jurisdiction, Central, which is the old West Star. We show we need it in Metro. So ultimately, there's a lot of gas in that 3-year period that we need to get constructed.
My last line of questioning is, let's talk about this particular case right now with West. OPC is saying that because you didn't have power to sell into the market, you didn't have the insurance, and therefore customers were at risk of volatility for higher prices because you weren't able to hedge that. Is it your position that had you had that capacity, the ratepayers would have saved more money, or is it your position that the capacity that you had, meeting the resource adequacy requirement from SPP, did no harm, held the ratepayers harmless because the volatility never occurred? It's not like Winter Storm Uri happened and the house burned down or the warehouse burned down, and therefore you didn't have insurance and the volatility was passed on. In that case, $300 million in securitization. In this case, did the warehouse burn down due to volatility, or did it not? Is this a penalty because you didn't have insurance and capacity, or is this a penalty because you didn't have insurance and capacity, you now had volatility that caused the ratepayers to pay more?
It's a little bit of a tangled question, right? But I think the answer is it's hard to determine, because when we would have constructed and built is unknown, because we never got questioned and deemed imprudent at any time in those prior plans. So you have to go back to when would we have built it? And then what would we have built at that time based on the factors we knew at that time? Would it have been coal? Would it have been natural gas? Would it have been nuclear? We would have had to go through that decision at that point with what we knew. And how would that cost bid into the market today?
So
would it be competitive, or would it be available capacity that didn't get turned into energy because its cost to hit the market was too high?
So this, I take it, is what Mr. Kleiser was saying in his opening, that if you take the position that everything is a look back, you never would have prudence for insurance, because you always would be of the position of, well, we didn't know what we didn't know when we didn't know it, so therefore we didn't need the insurance. That was his opening argument.
That is his argument. I would probably disagree with that. I think you have an opportunity to look at the facts at the time the decision is made, which is how you're supposed to evaluate prudence. And because you can only make a decision on a long-term resource based on what you know at that time. I mean, it's real easy today to say, gosh, if you would have done things differently in these 6 decisions over 20 years, you would have had a different market impact today.
Right.
Those are not things, those market impacts, while we evaluated scenarios at that time, they didn't pop out and say, build a facility.
So I just wanted to get clear though, your position is your current generation and your current accredited capacity is not cause for higher rates to your consumers. That's the harm that we're talking about. The company opened its testimony with, you have not, the two factors that we're deciding on rather this is disallowed or not, or if it's prudent or not, is one of those is you did not create harm, actual harm.
I would
Is that your
say,
position?
I would say our position is that current period harm from a decision that was made 10-plus years ago is not a factor in assessing prudence on that decision. That's a hindsight view because you're looking today at where the market ended up when you couldn't have known that when you made that decision 10 years ago.
Do you believe that if you were to, because sometimes OPC takes the position that new generation, that there's resistance towards investment in new generation. You think that this case is ultimately going to be an impetus for OPC to now support investment in new generation?
I think it's difficult to say. I mean, OPC and Mr. Kleiser alluded to this. They and staff both worked with us on the Dogwood CCN to bring that forward to the commission in an agreement that got that done. So that was certainly helpful and certainly will be helpful to West customers. I would say over the time of my involvement with resource planning here, there have been accusations that, and before my time even, there have been accusations that Metro and utilities like that might have been overbilled and were more costly to customers than they needed to be. There have been accusations that PPAs are not a good vehicle to utilize for customers. There have been assertions that the SPP market wholesale revenues or prices have to cover the cost. So I suspect one way or another, we'll be back in front of this commission, whether we're offering investments or market utilization or PPAs, with somebody having a contrarian position.
Thank you.
Chair Hahn.
Thank you, Judge. Just to follow up on a lot of Commissioner Holzman's questions, can you talk about the market during this FAC period and what was known or knowable at the time compared to the market now, how that dynamic has changed?
The market during the FAC period?
That's right.
Well, I think we were coming out, I don't have those dates in front of me, but I think we were coming off of Winter Storm Uri. The market at that time, post-Winter Storm Uri, had not recovered to pre-Uri levels. Gas prices were still high. There was volatility that was had not been in place since probably 2008 or 2009 in the marketplace. And then what we saw over the course of the period under review here was kind of that persistence of higher gas and ultimately higher energy prices than we had seen in that decade plus in front of it. And I think today you see that gas prices are back down to levels where they were before all those events. Energy prices have come back down and stabilized a little bit more. So I would call it, February of 21 to for sure getting close to the end of 23 was a period that was higher than we had seen in the 10 or 15 years prior to that, and higher than we would see today.
This is an interesting case because I think maybe what was known and knowable at the time in 2021, 22, is certainly different than what we know or know now. Can you talk about, you have talked about your plans to build going forward, gas plant 2029. Talk about the planning reserve margin changes at SPP, potentially changing what that may or may not do to your IRP, and if you do plan to accelerate gas plant investment, if so, where?
Yeah, sure. You know, if you look at what's happened over the last year or two, post Winter Storm Uri, SPP, like, you know, across the country, they've been looking hard at resource adequacy. First step was they moved our resource planning reserve margins from 12% over peak load to 15. So kind of a swipe of a pen, they added a 3% need for capacity from what was in effect the day before they made that change. They have been evaluating and currently looking at adding a winter reserve margin. Haven't settled on that number yet, but certainly that's a response to making sure that the market can look at resource adequacy seasonally. The expectation is that, again, probably by 2026 or so, they will further increase the reserve margin in the summer. Some would speculate maybe it goes up to 17, but TBD. Expected to go up, though, not down. And then, as importantly, they have been working hard to think about accredited capacity. You know, how much value do you get for your renewable resource? You know, if you have a 100 megawatt nameplate capacity wind facility, what are you going to get? Maybe it's under their new accreditation capacity, maybe it's 10 megawatts. And they're going to continue to evaluate that annually as the market continues to expand and contract with renewable resources. So they're lowering overall the capacity that they accredit for renewable resources, both wind and solar. They're also looking to do the same thing for dispatchable fossil resources. You know, rather than give you a full capacity level for natural gas, they're going to look at its capability to run and access the market, and it's going to lower the capacity that they ascribe to our dispatchable fossil. All of that works to put pressure on the need for us to add, whether it's dogwood, new builds, moving forward. The piece that kind of goes unspoken is load also matters. This commission's aware, I think, that there have been a couple recent announcements in our service territory for data centers, large load data centers that are going to need to be served in our service territory. And it is as robust a time as we've seen in decades for economic development in our states, whether it's the return of advanced manufacturing or more data center and AI focused centers. That will add pressure for us to build. So you'll see us continue to have accelerated needs. What you won't probably see is our ability to move up natural gas very far. Because if we have to construct it, if we can't buy another dogwood or something that's existing, we will have to start within this year or early next year to get it done by 29.
It seems like all signs point to accelerated gas plant, you know, steel in the ground. And that's for another time, another conversation. But, you know, I do appreciate the OPC's argument, you know, that seems like we need to own some generation. Now, whether that was known and knowable at the time is a different question. Whether customers were harmed, also a different question. But certainly recognize that now from all sides. So
There are a lot of factors that are coalescing on utilities and in the industry right now in terms of resource adequacy, no doubt about it.
thank you.
All right, thank you. Any further bench questions? Commissioner Mitchell, when you're ready, sir.
You bet. The testimony of Ms. Messmore and yours indicated that you had done some, in your integrated planning, although the two utilities, Metro and West, are treated separately in their operation, but in your planning process, looked at an overlay of how those two utilities would look or might look if they were operated together. I guess regulatory friction aside, how did those overlays look?
Yeah, so it's an interesting discussion, and I'm glad you asked that. It's worth talking about. When we put together an integrated resource plan and we look at that overlay, we're looking at the future, right? The next 20 years. What OPC has asserted today, and in this case, is, well, what if we take all the decisions and all the investments that were made historically and merge it? How could we make the impact to customers look? Which is a very different question. But forward, it hasn't resulted in a combined look for West and Metro that would have created a different decision than the standalone versions do. There's really a reason for that, because you're looking forward. One of the things that we're trying to solve for with the overlay is if Metro's plan calls for a retirement of IATAN in an accelerated time frame, but West plan says you've got to have IATAN longer, that would be the type of inconsistency we would want to catch with that overlay and come up with a preferred plan that creates the best outcome for IATAN if it's got those inconsistent views. We haven't run into that yet, but that's primarily why we do the overlay like that, is to make sure we're not making inconsistent decisions on shared resources as we move forward.
Understand, thank you.
Commissioner, thank you. Any other bench questions? I think I will have a few questions. If you've already answered these questions, please let me know. I'm not trying to get you to repeat yourself, but do you recall Commission approval of stipulations and agreements in file number ER 2016-0156 that resulted in consolidating MPS and LNP?
Yes, I do.
Did that order, I guess, contemplate a less than 1% change in the residential customer rates to those customers?
I don't remember that specifically, but I can tell you that we had the opportunity to have a few cases when they were separate, trying to get more alignment with our rate structures and with our rates before we got to the case where we did that combination. And we had the opportunity, as we filed that case, to consider rates that would be best fits for the combination and how we could minimize impacts to one customer or another. And we actually spent a fair amount of time with the OPC and with staff during the context of that case, kind of getting everybody on board with those rate designs and approaches that would, minimize the impacts to customers. So it doesn't surprise me.
Would Evergy consider 20-year PPAs as an alternative to building generation?
Evergy has considered historically 20-year PPAs as an alternative to construction. We have and it's in my testimony, we have a stipulation and agreement from one of the most recent rate cases that has some impactful shareholder concessions if we were to do PPAs prospectively. So we would have to factor that into kind of the comparison of owned versus PPAs moving forward.
Okay, thank you. In general, how are the charges of each PPA to Evergy determined? Is there a fixed capacity charge and a variable energy charge?
Yeah, so generally, our PPAs are focused on renewable resources, and they are pretty much set at a cost per megawatt hour produced by the facility. That cost embedded within that overall cost is what we're paying for energy, what we're paying for capacity, what we're paying for the renewable attributes. Usually those contracts don't break those components out. They just have an aggregate cost that you're paying.
Are those charges set for the length of the contract, or do they vary over time?
Varies by contract. There are a few that we've had that have been fixed, and there are a few, I think, that we've had that have been fixed for a period and then have some market escalation as you work through the 20 years. And then I think there are probably some that, have started earlier in the contract with some market inflators or adjustments. So negotiated at some level with the counterparty to the extent that you're acquiring from a developer.
Okay. In general, Southwest Power Pool's integrated market dispatches generating units based on least cost to meet the entire SPP energy load. Is that correct?
Yeah, based on lease cost, it kind of, the incremental or marginal cost. It doesn't, they don't consider all-in cost of a resource. Like if we bid in a natural gas facility, they're not considering the fixed cost of investment. They're just looking at kind of the incremental cost that facility needs to produce the next kilowatt hour, megawatt hour of power.
Do all of the Metros and West generation units clear SPP every day?
No, I'm sure they don't. You have a high renewable or a high wind day, you'll have a number of resources that won't clear.
Okay. Even though SPP considers Metro and West generation capacity as one, West bills its customers energy usage less its generation revenues by SPP. Is that correct?
I'm sorry, can you repeat that
I'll
one?
try. Even though SPP considers Evergy, Missouri Metro and West generation units capacity as one, West bills its customers energy usage less its generation revenues by Southwest Power Pool.
Yes, I mean, SPP considers them jointly from a capacity adequacy standpoint, but each entity pays for their share of their own capacity and their own energy procured and sold, the net of the revenues from the market.
And I think this is my last question, and if you need to get Ms. Mannel's direct in front of you, that's fine. It's just a question from her testimony. But on page 4 of her direct, she states load costs above revenues generated is an indication of inadequate resource planning by the utilities. Would you agree with that or not, and why?
Yeah, I don't have it in front of me, but I think I understand that point. I would not agree with that. I think that's inconsistent with the discussion I had with Commissioner Holzman that we didn't make all these decisions willy-nilly in a vacuum, right? I mean, we ran integrated resource plans for, in the case of West since 2007 that have indicated that having some level of capacity coming from the market or from Metro and some level of energy from the market was the least cost option for Missouri West customers. So I think that demonstrates that some mix is certainly appropriate. And, my testimony, I think, says throughout that, we think it's kind of all the above for advancing and serving customers, both from a resource adequacy and an energy standpoint, dispatchable, fossil, renewable, utilization of the market when the prices in the market, support that being the best option for customers. And we think that's the best outcome versus over-reliance on any single source.
Right, I don't believe I have any further questions. Thank you. Any further bench questions for this witness? All right, I'm showing the time to be 11:30. This looks to be a good natural break to stop before agenda. And as a reminder, agenda will be at noon and will be held in this room. And then we will plan to stand in recess until 1:30. Is there anything further from council or from the bench before we go into recess? All right, hearing nothing, we will be in recess until 1:30, and Mr. Ives will be back on the stand. All right, thank you very much. We are off the record.
Mic test, Emily, can you hear me? If you're on, Emily, can you hear that? Sounded like y'all were talking earlier, so.
12 p.m. and all commissioners are present, so we'll begin the agenda meeting for today, Thursday, May 22nd. I would ask those who are on the call to please mute your phone unless you need to speak. Before we get started, I know that this is an unusual forum for our agenda meetings, but we have had high attendance in our agenda room such that some participants were standing in the hall. So especially given the fact that we're having a presentation today, we are having it here in the hearing room. That may continue as participation ebbs and flows with what we have on agenda. So just be prepared for that, or changes to where the agenda meeting may take place. Today there are 5 tariffs and new orders, 1 case discussion, and 1 other discussion item, which is a presentation from Evergy. But first, we need to approve the minutes from the May 15th, 2024 agenda. Those minutes have been provided in advance. Commissioners, are there any changes or modifications to those minutes? Seeing none, all those in favor of adopting those minutes, please say aye. Aye. All those opposed? By a vote of 5-0, those minutes are approved. The closed minutes from May 15th today will be submitted for approval at next week's agenda meeting. Today, in terms of tariffs and new orders, the first tariff and new order is a case discussion that deals with 2 cases in file number ER-2024-0275 in the matter of the adjustment of Ameren, Missouri's fuel adjustment clause for the 45th accumulation period, and file number ER 2024-0277 in the matter of the true-up of Ameren, Missouri's fuel adjustment clause for the 42nd recovery period. On April 1st of this year, Ameren submitted direct testimony in a revised tariff sheet proposing a revised fuel adjustment rate. In this tariff sheet, Ameren proposed to revise the FAR of its FAC for the 45th accumulation period. Also on April 1st, Ameren initiated an FAC true-up for recovery period 42 and identified an overcollection of just over $2 million to be included in the proposed FAR. Staff made a filing recommending the Commission issue an order approving Ameren's proposed tariff sheet, subject to true-up and Prudence review. No other responses were received. Staff also made a filing that the Commission approved the over-collected amount from recovery period 42 for inclusion in Ameren's 45th accumulation period. Therefore, the order before us establishes that the true-up amount for recovery period 42 is an over-collection of just over $2 million and shall be reflected as a rate adjustment in file number ER-2024-0275. The order also approves the FAC tariff filing to be an interim rate subject to true-up and Prudence review. With that, I recommend we approve the order version number 1. Commissioner Coleman.
I support the order.
Commissioner Holzman.
I'm in support of the order.
Commissioner Kolkmeyer. And Commissioner Mitchell.
I support the order.
Great. All those in favor of approving this order, please say aye. Aye. All those opposed? By a vote of 5-0, that order is approved. The second tariff in order today is in file number ER 2024-0274 in the matter of Empire District Electric Company, DBA Liberty, for authority to implement rate adjustments related to the company's fuel and purchase power adjustment, and file number ER 2024-0276 in the matter of Empire District Electric Company, DBA Liberty, fuel adjustment clause or FAC true-up. On April 1st of this year, Liberty submitted its proposed tariff to implement its fuel adjustment rate, or FAR, for the accumulation period ending February 24 and the recovery period ending November 2023. Liberty also submitted an application containing its 29th true-up filing for its FAC and identified an overcollection of just over $2 million. Staff made a filing recommending the Commission issue an order approving Liberty's proposed tariff sheet subject to true-up and Prudence review. No other responses were received. Staff also made a filing recommending the Commission approve the over-collected amount from recovery period 29 for inclusion in Liberty's 31st accumulation period. Therefore, the order before us establishes that the true-up amount for recovery period 29 is an over-collection of just over $2 million and shall be reflected as a rate adjustment in file number ER-2024-0274. The order also approves the FAC tariff filing to be an interim rate, subject to true-up and Prudence reviews. With that, I recommend we approve the order version number 1. Commissioner Coleman.
I support the order.
Commissioner Holzman.
I'm in support of the order.
Commissioner Kolkmeyer.
I support the order.
And Commissioner Mitchell.
I support the order.
All those in favor of approving this order, please say aye. Aye. All those opposed? By a vote of 5-0, that order is approved. Third tariff in order today is in file number EO-2024-0002 in the matter of request for customer account data protection from Evergy Metro and Evergy Missouri West. This case involves certain Evergy data sought by staff as a result of Evergy's prior rate case agreement, which stated, if the requested data is either 1, not available, or 2, cost prohibitive to produce, the company will file a motion to establish an EO docket. I wish this case could have been resolved by the company and staff communicating with one another, as there were both data that was either available or partially available that could have been provided by the company to staff and should have already been provided, and data that was clearly cost prohibitive to provide to staff, which should have been recognized by staff as such. As reflected in our case discussion last week, the Commission is trying to strike the balance of provide what is low cost or no cost and not provide data that is cost prohibitive or does not otherwise already exist. The report in order before us reflects our case discussion from last week. It also directs Evergy to make a filing stating when it will provide staff the information the report in order directs Evergy to provide. With that, I recommend we approve the order version number 2. Commissioner Coleman.
I support the order.
Commissioner Holzman.
Thank you, Madam Chair. Where do we come down on the suggestion of conversation?
I think we encouraged conversation, but when we actually got off track on the discussion items because those particular items were involving the production of data that was potentially partially available but unknown. So that's what we ordered, is if the data is available to provide that partially available data, otherwise don't provide the data, but also continuing to talk.
But we're not mandating
No.
that they, okay, I support the order.
Commissioner Kolkmeyer.
Thank you, Madam Chairwoman. Your comments were very well stated, and I totally agree with them. So with that said, I will be supporting this order.
Commissioner Mitchell.
Madam Chairman, I'm going to abstain. But if it's appropriate, I would like to comment.
Absolutely.
First, I appreciate your comments, and I think as I listened to this matter, I was surprised that there wasn't a contemporary system analysis either available or on file that wasn't more than 3 decades old. So it's my sincere hope that we have the opportunity to talk about this again in the future, because I think that is a fundamental and foundational document that helps both staff and utility make informed decisions. That's all I'll say on the issue.
Great. Thank you for your comments. All those in favor of approving this order, please say aye.
Aye.
All those opposed? All those abstaining? By a vote of 4 in favor, 0 opposed, and 1 abstention, that order is approved. Fourth tariff in order today is in file number CA-2024-0284 in the matter of the application of Green Hills Area Cellular Telephone for expanded designation as an eligible telecommunications carrier, ETC, for purposes of receiving federal and state lifeline and disabled support. On April 3rd of this year, Green Hills Telecommunications Service requested designation as an ETC to be eligible to provide lifeline service. Green Hills Telecommunications Services requests ETC designation on a statewide basis for the purposes of receiving federal low-income support. Green Hills also request waiver of the commission's 60-day notice requirement. Staff conducted an investigation and on May 6th filed its recommendation to approve Green Hills' request as they meet the requirements of the commission's rule governing ETCs. Therefore, the order before us grants Green Hills' request for ETC designation and a waiver of the 60-day notice rule. With that, I recommend we approve the order version number 1. Commissioner Coleman.
I support the order.
Commissioner Holzman.
I'm in support of the order.
Commissioner Kolkmeyer. And Commissioner Mitchell.
I support the order as well.
Great. All those in favor of approving this order, please say aye.
Aye.
All those opposed? By a vote of 5-0, that order is approved. Fifth tariff in order today is in file number CG-2024-0172, Kearney v. Spire, Missouri, or DBA Spire. On April 4th, the complainant filed a second amended formal complaint. There were no responses to the second amended complaint. Also on April 4th, the Commission issued an order directing the filing of procedural schedules by the parties. Spire, staff, and the complainant all made filings in response. The Commission has considered the filings, and the order before us grants the complainant's second motion to amend the complaint and sets a procedural schedule and certain procedural requirements. With that, I recommend we approve the order version number 2. Commissioner Coleman.
I support the order.
Commissioner Holzman.
I'm in support of the order.
Commissioner Kolkmeyer. And Commissioner Mitchell.
I support the order.
All those in favor of approving this order, please say aye.
Aye.
All those opposed? By a vote of 5-0, that order is approved. Next, for the agenda, we have case discussion and file numbers EO-2023-0407 and EO-2023-0408. This is regarding Evergy's MIA Prudence reviews. The hearing in this case is scheduled for next week, May 29th and 30th. Judge Hatcher, would you please come forward and provide us any updates in this case?
Thank you, Chair Hahn. As you've mentioned, the case is happening next week. The memo I have distributed to the commissioners includes the position statements from the parties for each of the issues. There are 5 issues, and the first 4 revolve around Nucor and taking service under the SIL tariff and also participating in the business demand response program. The last issue involves both Evergy Metro and Evergy West with various administrative and conference costs.
Thank you, Judge. Are there any questions for the judge? Thank you, Judge Hatcher.
Thank you.
Thank you.
Before we go on to the presentation, we're going to go to scheduling so that we can adjourn after the presentation. So I'll quickly run through scheduling. Of course, today and tomorrow, we are in an evidentiary hearing in the matter of the 5th Prudence review of costs subject to Commission-approved FAC of Evergy, Missouri Metro here in the same room with Judge Pridgin. Next week, as just on case discussion, Wednesday, May 29th through Thursday, May 30th, there's an evidentiary hearing in cases EO 2023-0407 and EO 2023-0408 in the matter of the 2nd Prudence review of MIA Cycle 3 energy efficiency programs of Evergy, Missouri Metro, and here in room 310 at 10 a.m. with Judge Hatcher. Also, next week, Thursday, May 30th, we will have agenda at 1 p.m. Tuesday, June 4th, there is a rulemaking hearing in 2 rules, one regarding the Commission's rule on stipulation and agreements, and the other one in the matter of the amendment of the Commission's rules regarding intervention here in room 310 at 10 a.m. with Judge DePel. Wednesday, June 5th, we have agenda at 10:15 a.m. Monday, June 10th, there's a discovery conference in case GR-2024-0106 in the matter of the request of Liberty Utilities, or Mid-States Natural Gas Corp., to implement a general rate increase for natural gas service in room 305 at 10 a.m. with Judge Hatcher. And then also Wednesday, June 12th, there is agenda at 9:15 a.m. Commissioners, are there changes or modifications to schedule? Commissioner Kolkmeyer.
Just a question, next Wednesday, the 29th, is that a 10 a.m. start?
It's a 10 a.m. start. Oh, that's agenda, but the hearing
But
that
the
day is
hearing,
a 10
the
a.m.
hearing.
start, but we have agenda at 1. Oh, did you say agenda?
I may,
Sorry.
no, the hearing.
Okay, the
I'm
hear-
after the hearing
Okay. Hearing's at 10, agenda's at 1.
on Wednesday.
Agenda's at Thursday, so there's a hearing, the hearing is 2 days.
Okay.
And so agenda is on the second day of the hearing at 1.
And both days' hearings start at 10 a.m.
Yes.
Thank you.
Okay. Other questions or modifications to the schedule? Seeing none. Now we're going to go back to our other discussion, and we have a presentation from Evergy on EPA regulations with CEO David Campbell and VP of State and Regulatory Policy Kevin Gunn. Please come forward. Okay. Oh, no, I was like, yeah. Thank you. Please proceed when you're ready.
Thank you. Chair Hahn and Commissioners, thank you for the opportunity to present today. My name is David Campbell. I'm the Chairman and CEO of Evergy, and I'm here to describe a series of EPA rules that were issued in late April. There's a lot of work still to be done regarding the implications of the rules, but they are very consequential. So we thought that it would be helpful to provide some of the summary perspectives early on, because we'll be generating a lot of work for us and other utilities in the state over the coming months and years. So I will walk through the presentation that was provided. I will not hit every bullet point. Please, of course, interrupt with questions at any time. There were 5 different rules issued in late April. Rules regarding greenhouse gas emissions, and sorry for the alphabet soup of acronyms. These EPA rules and this presentation are a thicket of acronyms. Greenhouse gas rules for existing coal plants, greenhouse gas rules for new natural gas units, new rules regarding mercury and air toxics, new rules regarding effluent limitations relating to water discharge and water use, and new rules regarding coal combustion residuals or coal ash. And my presentation will focus on the greenhouse gas rules in particular today. We expect it will be, our company, I can't speak for others, of course, will be relatively well positioned with respect to the latter 3 rules regarding mercury and air toxics, effluent limitations, and we hope regarding coal combustion residuals, some more work there. But the GHG rules are the ones that we're doing the most work on and will have the biggest implications relative to current plans, we expect. And of note, as EPA had signaled before, the greenhouse gas rules do not apply to new natural gas units. I'm sorry, to existing natural gas units. It's existing coal and new natural gas, but existing natural gas is excluded from the rules. Okay, so first of all, for existing coal-fired units, so these are all the coal plants that are in operation today, a series of different categorizations based on the expected retirement date. If you expect to retire your coal unit after 2038, you have to have carbon capture and sequestration, or carbon capture and storage, in place beginning January 1st, 2032. Of note, there are no natural gas or existing coal units in the United States today that have carbon capture and storage in place. So this is not a proven technology at scale in any units in operation in the U.S. today. And the rules say if you want to operate past 2038, it has to be in place by the beginning of 2032. For units you expect to retire between 2032 and 2038, you need to have natural gas co-firing. There's an emissions rate that's set by the rules. Natural gas co-firing that's equivalent to 40% of the total fuel supply. So the rate is set at a level that implies 40% fuel source is natural gas, 60% is coal, measured over a year. So it doesn't mean every minute or every hour, but it's measured over a year. Of note, there are 4 different coal plants that serve our Missouri customers. One of them, Hawthorne, has a natural gas line and has sufficient natural gas capacity to be able to meet the standard. 3 of our coal plants do not have natural gas infrastructure. So to meet this standard, the first step we'd have to do is permit and build natural gas pipelines and then contract for the gas. For units retiring by 2031, the end of 2031, there are no additional requirements imposed by the rule. And we have a couple units that would fall into that expected timeline, so no consequences. But of note, about 80% of our fleet is impacted relative to their expected retirement dates in the first two categories I described. And this proposes additional requirements. For new natural gas, and this is relevant for us and many other utilities around the country and other utilities in the state that plan to build new natural gas. Again, the standard that's established for any units running over a 40% capacity factor, effectively any baseload units, and that would typically be your combined cycle natural gas. The most efficient way to generate electricity out of a gas turbine is through a combined cycle unit. There's a limitation of a 40% capacity factor after January 1, 2032. To run at a higher capacity factor, you have to have carbon capture and storage in place. And again, there's no existing natural gas unit that has carbon capture and storage. So we have to design, build, install, cost effectively put in the infrastructure to capture the CO2. And we also have to have a pipeline and storage infrastructure in place. None of that exists today. If you have a peaking unit or a lower load turbine, you can run up to 40% as long as you meet the emissions requirements. And it's expected that the new gas turbines, the highly efficient new gas turbines, will meet the requirement. You can have those in place, but you're subject to that capacity factor limitation. So the biggest consequence of this rule is if any utility, and we had in our plans, expected to build a combined cycle unit to be able to provide energy cost effectively, there's a 40% capacity factor limitation. So you'd have to have additional sources for that energy. You could not run a combined cycle unit higher than 40% after 2032, unless carbon capture and storage technology is developed and can be deployed cost effectively, including the pipeline infrastructure. There are a set of flexibilities that are embedded in the rule, and this was a subject of extensive advocacy, and EPA did include those. So these are noteworthy. And I should say that each state has to file a plan relating to the greenhouse gas rules within 2 years. That has to list the retirement dates for the coal units in the state. And it also can set a statewide overall plan for how any trading, for example, might occur. And any unit-specific mass balance requirements. So that is in the purview of the state, but it has to be approved by the EPA. So the state needs to approve a plan, and then it needs to be submitted by EPA. EPA then needs to approve it. Other things that could be requested by states, there could be a 1-year extension requested for liability purposes or for the installation of additional control equipment. States can take into consideration an asset's remaining useful life. Short-term relief mechanisms are possible during emergencies. Obviously, that is less relevant if a unit's already retired. And states, as I mentioned, can have a trading scheme. Now, on paper versus practical reality, it's hard to know for certain how these provisions will work because a state plan has to be approved by EPA. So, for example, if it's a blanket extension that's requested, there's a little uncertainty as to whether the EPA would approve that. And for planning purposes, given how near these dates are, utilities are going to be faced, if it takes 5 years to build a gas plant, for example, if there's a good chance that coal is going to have to retire as required under the rule, we and other utilities will have to start that planning likely in advance of when a state plan is even submitted, let alone approved, including exemption requirements. But it is noteworthy, these guidelines do include these requirements, just a little bit uncertain as to how and in what fashion they might be applied. You won't be surprised to hear, given the history of some different EPA rules, a lot of litigation has already been filed relating to the rules. The petitions for review have been filed by states. They've been filed by industry coalitions, trade organizations. These include both challenging the rule and its legal requirements, but also challenges asking for a stay motion. These will be filed with the federal DC Circuit. That's the court that hears this. It's the appellate court that hears these appeals. This second to last bullet point notes we plan to participate. We have joined a coalition that is challenging the rules. It's with several other utilities, as well as American Public Power Association and others. It's a group called the Electric Generators for a Sustainable Transition. We're part of that group. Sorry for the mouthful of a name. It is not uncommon to have this kind of litigation occur with major rules like this. So of course, there's an uncertainty as to how long it may take. Without a stay motion, litigation, obviously, as we know, can take a few years. So given the timelines for the rules, I think all utilities will need to start developing plans that comply with what is prevailing rule. But we'll obviously keep the commission informed as the litigation process unfolds. It'll be widely covered. We believe on our initial analysis that we're well positioned to comply with the MATS, ELG, and CCR rules. The coal combustion residual rule is likely to identify either going back to existing landfills and potentially putting new requirements. So it has some uncertainty as to cost. That has happened in the past, so we're hopeful we've got a methodology that can be applied to manage it. And we feel pretty good about our control equipment for MATS and ELGs. But for the greenhouse gas rule, as I mentioned, relative to our current integrated resource plan, about 1,400 megawatts of capacity, nearly about 80% of our coal resources has an earlier timeline that would need to retire or have carbon capture and storage in place if that technology can be developed. And each utility will have its own timeline for it, but anyone who invested in particular in control equipment as we did is relatively well positioned, somewhat ironic, to comply with the MATS and ELG and CCR rules. But those investments help to enable a longer expected useful life for those units. So those are the ones that are most at risk under the carbon capture and storage rules because they have longer planned lives because the investments that were made to comply with the regulations on existing pollutants. So again, that concludes the prepared remarks, other than to summarize, to say that the integrated resource plan we filed a month ago did not include the implications of this rule because it hadn't been published yet. But we and other utilities will be spending a lot of time, absent a stay of these rules, particularly the greenhouse gas rule, over the next year developing what our plan will be. We'll need to work closely with the states as they develop so the state of Missouri, as it develops its plan, that includes a comprehensive view of the compliance plan for the greenhouse gas rule. So busy times ahead, very consequential. The biggest impacts for us we see will be on the affordability and potentially the reliability front, because it does involve planning for earlier retirements and therefore new resource additions relative to what's in our current plans. So that will mean incremental cost. The potential reliability issues would be if we can't build sufficient new resources in time. Again, it's a little hypothetical. There are potential relief mechanisms if you can get those approved. It makes for a complicated time for the most cost-effective planning for 20 to 30-year investments. But there are affordability and reliability consequences potentially for this, as you'll have seen in a lot of the published reports. Southwest Power Pool has issued a release with its concerns about potential reliability implications yesterday, as have some other RTOs around the country. And with that, I welcome any questions you have.
Thank you. I do have a question. You touched on both reliability and affordability. Does Evergy have any cost estimates at all of, with these rules broken down individually, cost implications? I've heard of one plant, I can't remember if it was Michigan or Minnesota, that does have some form of carbon capture, one plant. And even to upgrade that plant to come into compliance was still a couple $1 billion. So if you have 4 coal units and potentially new gas, do we have any?
We don't today, and there's not a plant that operates at the size of our units that has carbon capture and storage today. So everyone's estimating at some level. So it's one of those pencil estimates that probably can only get higher. I do have a colleague who works in one of the Michigan utilities. They are hopeful that they have good storage infrastructure nearby. So they basically have salt domes, which we don't have the equivalent of. I anticipate, based on the technology that's available today, that it would more likely be new units that we would need to build as opposed to trying to retrofit, because the technology cost is uncertain and the ability to develop the infrastructure to safely sequester the carbon is unknown. So rather than sort of jumping off the building, hoping that technology develops in time before you land, we would likely need to be building new. Now, if it's about 1,400 megawatts, the estimates vary, but if you argue that's, if it was all replaced with gas, if you do a ballpark of 1,250 a kW or 1,500 a kW, that gets you up to $3 billion-ish. give or take, which I hate to give such a high-level estimate. But we need to work through that systematically, so that's just an example. And if you could replace it with a mixture of solar storage and natural gas or other resources, wind as well. Wind is less likely to be able to provide the capacity because it's accredited at lower levels. So it'll likely be solar storage and new natural gas, particularly new natural gas.
I've also read that the geology of certain states doesn't necessarily allow for carbon capture and storage and pipeline infrastructure. Can you speak to the geology of Missouri, if that would be feasible or not?
So I'm developing my expertise on the relative geology of our region. So it's still, this is more of a tentative answer, but my understanding is we don't have great natural storage capacity. So, for example, there's been a lot of salt production in central Kansas, but that has not been in the kind of salt domes that readily lend themselves to storage in a lot of parts around the country. So you can create storage capacity, but that would just be, we don't have the natural resources, if you will, the kind of caverns that we can store in as readily, to my understanding. You can build pipelines, you just have to get them permitted, and it's costly, of course. So it's again, if I were to estimate today, the more cost-effective path is replacing rather than trying to make a bet on uncertain CCS retrofit technology as well as storage capability. But we'll do more work on that, and I will become more expert on the geology of the region. Depends a little bit also on where the plants are specifically.
Has DNR convened any public stakeholder meetings on this rule yet, to your knowledge? No? Just seeing if anybody?
Not to my knowledge. Still mobilizing, a lot of coalitions are forming, sir.
Commissioner Coleman, do you have any questions? Commissioner Holzman?
Thank you for the presentation and the information. From a macro perspective, often well-intentioned bureaucrats will come up with plans to solve complicated social problems. Have your engineers evaluated what the true impact will be if these rules were fully implemented? Will they have the desired result that they seek?
It's a good question. So it's a macro question. We certainly haven't looked at it from the mass balance U.S. perspective. In practice, to ensure adequate capacity, new natural gas is likely to be needed as part of the transition. So if you're replacing retiring coal with new natural gas that runs with a 40% capacity factor limitation, you will reduce GHG emissions. Typically, a efficient gas unit will run at 40% of the CO2 emissions rate. Getting it at zero, though, over time is going to require technological advances, and we in the industry do think that there's potential promise for carbon capture and storage. My personal view is it'll work if we can get the technology to work, and around the globe there's enough investment, we'll probably get there. This time frame will be really tough, but it may not work everywhere because of the storage infrastructure. Getting to net zero is going to take more years, and it's going to require innovation in probably new nuclear, innovation in CCS, but this time frame, the macro objectives, I think they're more, a lot of the objectives are in terms of the overall global balance of GHG emissions. Obviously, given the coal emissions in places like China and India that continue to expand, can't really comment on those. That would be hard to achieve. But these rules will certainly challenge coal plant existence, which is part of the narrow objective of the rules.
So you recently acquired Dogwood as a natural gas plant. Is that acquisition, has that gone through in time for it to be an existing asset in your fleet that is not going to be subject to this?
It is an existing asset, and the ownership change won't impact that. So the Dogwood style asset is not covered by.
Does that create more value for those assets, potentially?
Yes.
Okay. Do you think that these rules will have the intended or unintended consequence of being a catalyst for renewable storage development? I know we talked about carbon storage, but I'm talking about dispatchable storage.
I think generally, yes. I think there's a lot of factors that are driving that kind of technological innovation already. So the expansion of data center demand and a set of customers who are interested in having storage as part of the solution, and the overall push, with ongoing demand from electrification. All utilities are facing incremental load requirements. We're not investing in new coal units. So I think there's a lot of energy behind pun, but there's a lot of investment behind storage technologies already. This will provide further impetus for it, but I think there's a lot of impetus for that already, given the nature of expanding resource needs and the reality of folks are gonna, the fleets are transitioning over time, and that will happen. This challenges with this rule is how soon, and requiring a technology that we don't believe is commercially demonstrated to be viable, cost-effective at this time.
What do you envision being the involved stakeholders as this goes forward? We're talking about the commission as a body, the legislature, the state legislature. Do you envision the federal government, on a legislative level needing to get involved if it determined that the time frame isn't plausible?
I think the courts will definitely be involved, so the federal courts will be involved in evaluating the rules. State environmental agencies and state commissions will be involved because the state plans have to develop, and the state plans will need to involve some level of coordination. If there is going to be a trading program, for example, or allocation across different utilities within the state. So there'll be a heavy role for states. The federal EPA, of course, will continue to be involved in evaluating those state plans. State legislators less role to play, given that's a federal rule. Federal legislation, your guess is as good as mine. Certainly, there could be a role for it. But some of the legal challenges will challenge the fundamental basis for whether the EPA has the authority to regulate greenhouse gases. But a big chunk of the legal activity we'll focus on is carbon capture and storage. Does it meet the standard to be actually required in this time frame? Is it actually demonstrated to be commercially viable? And that's where we think we and others will spend a lot of our energy saying, hey, it's not. We hope that it gets there, and there's a lot of work underway on it, but it's not there yet, so it doesn't meet the standard for the rule.
Do you envision your next IRP update to include the implementation of these rules?
I think that absent a stay, I think we have to develop an integrated resource plan that complies with prevailing laws.
Okay, thank you.
Commissioner Goldmeyer?
Just a comment, Madam Chair. To my knowledge, Conway, Kansas is the only place there are salt mines. There may be some closer that are being used today, and most of those are full of propane in Conway. Or do you know of any other salt caverns closer?
I don't, but I admit that's an area where I want to learn more. My bigger concern is that we don't know what the retrofit technology would cost, let alone the cost of building out the storage transportation network to get the storage location. But we're learning more about the geology. My understanding is our readily accessible geological locations are more limited for us, to your point.
Yes, agreed.
Yep.
Commissioner, you have more questions? Commissioner Mitchell?
Yeah, just out of curiosity, apart from storage and salt domes in Morton, Kansas, what other technologies do you envision being even viable? I mean, noting that none of them are at scale today.
Yeah. So for carbon capture and storage, it is going to require retrofit equipment and then a transportation network and then a place to store it. So that's a lot of question marks on that. And I don't mean to sound bearish. I think we could get there over time. But I think it's all then about what can you replace it with most cost effectively. Right now, the most cost effective way if you were to retire capacity in our region would be natural gas. But solar is also a strong resource potential. We don't have much solar in our system in Missouri and Kansas. So there's room for solar to come in. It can replace the energy from coal. It's got a good profile. We have a lot of wind, but that profile doesn't match up quite as well with peaks. But if you're going to have solar, you need to have storage alongside it to firm up the dispatchable capacity. And right now, the most cost-effective solar technology are 4-hour batteries, which, if under the SPP rules, those qualify for firming up solar and gas, then that could be a combination of add renewables plus storage. But if we have tighter and tighter winter reserve margin requirements, I expect we may see a longer duration requirement than a 4-hour battery. There aren't yet any longer duration batteries that are deployed at scale because they're not as cost effective. So it's a lot of research in that, to the question earlier though. So long duration storage, natural gas, solar, wind, and then the new nuclear if possible. And I'm asked a lot of questions about new nuclear, and I generally describe it as probably 10 years out at least. because the conventional new nuclear that was installed in Georgia was likely cost prohibitive for others to, I think it was $25 to $30 billion for the 2 units. And new nuclear may have promised, but there are no new nuclear units, the small modular reactors, under construction yet in the U.S. I think for our Missouri and Kansas customers, we're going to want to have a lot of confidence in the cost before we embark on that journey. I hope we get there. And they're starting to build some in Canada. They'll be first. So nuclear I would be very excited if new nuclear could be part of the mix, but it's not something that pencils out yet.
And you envision by 2039 or the implementation deadline that there'll be no coal in the fleet?
Well, I think that, I do think there'll be coal in the fleet for example, our Hawthorne unit through 2038 will have natural gas. So for the units where you can get gas infrastructure in place to get co-firing, so that if we can get the gas lines to the 3 units that don't have it today, they could buy it till 2038. Now you need to declare whether you're going to be retiring after 2038 and 30 into the rules now. Well, let's say that there's flexibility ultimately if we can get CCS done. Could CCS be ready by the end of 2038? Potentially. But under the rules written, if you're going to stay open past 2038, you have to have CCS in place by the beginning of 2032. That's a big question mark. Could we have CCS by the end of the 2030s? I think we could, because I think it's something that around the world there's going to be a fair amount of investment around. But I like flexibility in making decisions, on technology available today, but making investment decisions that you can stay flexible over time. Will we be seeking, for example, will we be part of a group seeking a stay is say, hey, the intent behind these rules, coal plants are older, we're gonna transition away from coal over time, but you need to give enough time for the technology to be there. I'm a believer that technology will be developed by end of 2031. When we have to make decisions 5 years in advance to start building, it's too soon, in my view.
Thank you.
One other question. We've talked about gas plant for your specific company coming 2029, and you've said that your current plan doesn't contemplate these rules. In your thought process, if you say the answer is potentially new gas, how fast? Like, what could be the accelerated timeline, or is 2029 the most accelerated timeline?
Given permitting and SPP interconnection requirements, I think 5 years is the soonest. Now, the coal plants, even if you don't have any compliance plan, you have till the end of 2031. So it's just going to be a matter of, do you want to, launching on those, it's a lot of new gas to build. I think one of the things that will be I don't know if it's quite a no-regrets move because there's still time and money involved, is seeing if we can permit natural gas lines to the 3 coal plants, because that at least gets you to 2038. But it'll likely be a mix of working on the gas lines, the next year before we file our next integrated resource plan, is working on can we get gas infrastructure in place, and then what other new gas might be there. Recognizing that we've got a kind of a demand explosion happening, driven by data centers and other factors, so there may be other reasons to build new. But if you're building new to support incremental demand, that usually is a good thing, because you'll spread costs, your existing other fixed costs, you'll spread over that new demand. It's when you're building infrastructure to place existing infrastructure that still has a fair amount of rate base, that's when it creates affordability questions.
Natural gas as a resource, how much capacity do you think we have, in reserves in the United States?
We have plenty of natural gas, and I do think over time we are going to use less natural gas. Utilities around the U.S. are busy building new natural gas, no question. But at the same time, we all have significant amount of renewables resources we're adding to our system. So the capacity factors for gas units, I think overall will drop over time. So I think we have plenty of gas. We have natural gas resource potential in the U.S. is phenomenal. It'll be pipeline infrastructure will be the bottleneck. Can we get enough pipeline infrastructure in place, particularly for firm gas in the winter? That will be the question.
What's your thoughts on, we've been looking a lot at virtual power plants, taking the dispatchable storage behind the meter so that the customer has customer generation and on-site storage that could be moved to sort of create a model. We have software now that the utility can become a mini RTO and actually change the dynamic to where the utility is controlling that power, displacement. What is your company's vision of that type of technology being a part of the solution?
I think that demand response and virtual power plants and more flexibility will be a very important element of the mix going forward. Now, I want to be careful when I think about
It's not going to fund a data center, but
some people hear utilities controlling everything and they have bad thoughts around it. But the positive is if, for example, a data center that's building a large language model, and I know less about AI than I do about geology, but I know a little bit. So if a power plant is building a large language model, that's not when all of us are on our keyboards asking requests for ChatGPT and expecting we're going to get a response right away. That may be, when it's building a model, incredibly power intensive, but maybe that could be interruptible. How many emergency events do we have? Hopefully not too many, so it wouldn't be that often. So storage that every person has in their electric vehicle in a smaller scale to storage devices behind the meter to interruptible large loads. I think the more flexibility we have, I think will be the more technology today enables a lot of that flexibility. I think will be an important part of the mix. A lot of that comes down to our customers willing to participate and the behavioral change along with it. I think if there's, we have rate design, so the rate design elements to help to encourage that. But I do think that technology enabled both the storage side and the interruptibility side and the dispatchability, the system design piece, I think it is going to be an important part of the mix.
okay. Thank you very much.
Any other questions? Seeing none, thank you so much for your presentation.
Thanks again for your time.
Thank you. And any other discussion or items from the commission? All right, seeing none, we're adjourned.
when we left at lunch, Mr. Ives was on the stand, and he's still on the stand. I'll remind you, you're still under oath, sir, and I believe Chair Hahn may still may have a few more questions for you. So, Chair Hahn, when you're ready.
Over lunch, I was contemplating, I thought of a question that I hadn't asked previously. If we were to, the commission were to take public counsel's position of disallowing I can't remember if it's 82 or $86 million, but their position is also you should have built, you should have owned generation. What would that disallowance do in your ability, what effect would it have on your ability to access capital from the markets to build or additional generation?
Well, the easy answer is it would put some level of pressure on access to capital markets. $86 million disallowance and an impact to shareholders. And our math is, 30 cents a share, something like that. That would cause a flight of some investors and probably an outcry from some investors to, reconsider the level of investment that they would like us to be making in Missouri under that sort of regulatory construct. So in both those situations, that put more pressure on capital market access as you move into the next stage of investment or build for sure.
That answers my question. Thank you.
Chair Hahn, thank you. Any further bench questions? Right, hearing none. Any recross based on bench questions? Mr. Keevil.
Just a couple here, Mr. Rice. There were several questions earlier, I believe from Commissioner Holzman, about your acquisition of Dogwood. Do you remember those?
I do.
Now, remind me, was that Evergy West, or who exactly was doing the acquisition in that case?
Evergy West acquired Dogwood.
That was West. And if I recall correctly, you didn't acquire all of Dogwood. Is that correct?
Yeah, that's right. But I appreciate you asking that question because it gives me a chance to clean up one mistake I made with Commissioner Holzman. I think we talked about my recollection that might be around 300 megawatts. I overshot the mark on that. It was closer to 140 megawatts as our share of the Dogwood facility.
That's what,
And that's going to be about our share with that acquisition is about 22% of the Dogwood facility. So we'll be a minority owner in that consortium.
Right, okay. So that was eventually where I was going, was your percentage ownership of Dogwood is not 300, it's, what'd you say, 140?
It's about 140, 145, something like that, and about 22% of the overall facility.
For some reason, I was remembering 22%, but I couldn't remember what the megawatts were. There were also several times during his questioning and also during your answering that the words energy and capacity were sort of used interchangeably. You would agree, would you not, that there is a distinction between acquiring energy and acquiring capacity?
I would agree there's a level of distinction, but there's certainly some interrelationship with it, right? I mean, capacity and the ability to provide energy certainly unlocks some energy, right? Mm-hmm. But you're still subject to, with capacity, you're still subject to when and how that facility's going to operate and when the SPP market is going to call upon that facility to produce energy. So they can diverge, but in some respects they are related to each other, if that makes sense.
Yeah, I agree. But you would agree, I think, that you could go out and buy energy, or you could buy capacity, or you could buy both.
That's correct. You can acquire one without the other.
Okay, thank you. That's all I have, Judge. Thanks.
Mr. Keevil, thank you. Mr. Kleiser?
Oh, thank you, Your Honor. Good afternoon, Mr. Ives.
Good afternoon.
So you received quite a few questions from Mr. Holzman, and as part of that, I'm very sorry, Commissioner Holzman. As part of that longer conversation, there were some questions kind of brought up regarding the history behind our argument. Do you recall that?
A little bit, yes.
Yes, and at one point, I think you even expressed that Evergy West has never been questioned on the prudency of its decision. The OPC has expressed concerns regarding the company's inability, or nope, let me rephrase that. You would agree with me that the OPC has raised the arguments effectively raising in this case before, right?
I would agree that the OPC has raised questions about items that have come up in our integrated resource plan. I wouldn't say that that I can recall specifically raised and had sustained any sort of argument around a specific prudence of a specific decision. So, which I think is kind of where you are today, right? You're talking about a bunch of stuff over time has led to a spot where Evergy, Missouri West is accessing energy from the market. And I think that's kind of how you've couched your argument in this one. You said it's not any specific decision, but overall, there's an over-reliance on the energy market.
Right. Your Honor, I'm going to distribute something. I'm not asking it to be marked because it's already an attachment to another person's testimony, but I'm distributing it now for discussion purposes. And for the record, I just want to, again, reflect that this should be attachment S5 to Lena Mantle's surrebuttal. So I'm not asking for it to be marked, but I'm going to discuss it here for this purposes. And really, I just want to touch on the idea of whether or not the OPC has been addressing this concern before. And what you have in front of you, Mr. Ives, are the comments filed by the Office of Public Counsel in a integrated resource plan filed by KCPL Greater Missouri Operations in 2017. And just for the record, KCPL Greater Missouri Operations is the predecessor to the currently existing Evergy Missouri West, correct?
That's correct.
And if you turn to the memorandum, beginning on page 2 here, beginning on the third full sentence, which is 1, 2, 3, 4 lines down. You would agree with me that the OPC stated, OPC is also apprehensive that the premature retirement of approximately 900 megawatts of capacity, GMO and KCPL combined, creates a significant risk by not fully accounting for the highly uncertain interdependent energy market and policy arena.
Oh, I'm sorry. Can you, I see the 900 megawatt, but I'm not seeing the rest of the words lined up. So can you remind me where you are? Page 2.
Sorry, yes. Memorandum, page 2. 1, 2, 3, 4 lines down is where I'm starting. 1, 2, 3, 4, 5 words in where it says OPC is also apprehensive. And I should say it's page 2 of the memorandum. That's the confusion I have. I apologize for you. Because this is the attached filing with the memorandum.
Perfect.
There you go.
Thank you.
I see where I confused you now. Are you with me now?
I am.
So again, OPC is also apprehensive that the premature retirement of approximately 900 megawatts of capacity, GMO and KCBL combined, creates significant risk by not fully accounting for the highly uncertain interdependent energy market and policy arena the revised preferred plan would operate in. More specifically, the premature forced closure of large amounts of dispatchable baseload serving generation in favor of unknown capacity contracts through the SPP energy market raises prudency concerns moving forward by potentially producing significant stranded costs, increased risk exposure from market volatility, and future reliability concerns. You would agree with me with how that reads?
That's what it says, yes.
And you would agree with me, therefore, that the OPC has at least been addressing these concerns regarding Evergy West's reliance on the SPP energy market from, at a minimum, this 2017 triennial IRP filing, correct?
Yeah, although, I mean, I would just say right there in that same paragraph, it goes on to say, the primary concern centers on the early retirement of Sibley 3's 364 megawatt. And I think, I've got testimony out there that pretty clearly shows the commission has specifically addressed that one and indicated that they believe that the decision was considered prudent for that. So although you're raising it, just because you say it doesn't hold it to be true. The commission has made some orders that have said otherwise.
And that's certainly the case, and I'm not disputing you on that. My point, and I think, again, that you would agree, is that the OPC has at least been addressing this concern to the company for as far back as 2017.
You have raised that concern that you read, yes.
And do you happen to have a copy of Ms. Lena Mantle's direct testimony in front of you?
I do not have a copy of that in front of me. I apologize.
Find me your copy. Direct. This is the only page I'm going to talk about. It's page 16. If you don't mind, I don't have the entire one. I can provide you the entire one if necessary.
Yeah.
If you feel it necessary. I guess I should just do that. Can you find page 16 for me of Ms. Mantle's direct testimony?
I'm there.
And you would agree with me that Ms. Mantle testified, beginning at lines 12 through 15, that the OPC raised its concerns regarding Evergy West's resource plan's increased reliance on energy purchased from the SPP market in at least the following cases, and then she has those cases listed.
I see the list of cases, yes.
And you did not file any testimony in rebuttal or surrebuttal to contradict that the OPC has been raising this issue in the cases that was asserted by Ms. Mantle, correct?
I talked about some of these cases. I certainly talked about some of the cases where Ms. Mantle raised these items and the commission disagreed that there were imprudence. So that's certainly in my testimony. I did not address each and every case. I think Ms. Mantle also lists some cases, starting with like 2005 and 2007 in her testimony in this case as well. And I didn't go back and rehash all that history for this review period either.
But are you disagreeing with Ms. Mantle that the OPC has raised the issue regarding the Evergy West's reliance on the SPP energy market in all the cases listed there?
I don't. I just don't think it's relevant to the prudence discussion in this docket.
That's going to be a mess. One of the questions that you were asked from Commissioner Holzman concerned sort of the impact of the volatility. Do you recall that kind of line of questioning?
Yes.
You wouldn't happen to have a copy of Dr. Mark's testimony in front of you, would you?
I do not.
No, don't worry, Lena. I got this one. Your Honor, again, I'm going to distribute something. This is for discussion purposes. I'm not asking for it to be marked.
I'll trade you.
Didn't give Mr. Fortson a blank piece of paper.
That happens, I apologize. Now, Mr. Ives, I'm going to posit to you that this is representing page 5 of the surrebuttal testimony of Dr. Jeff Mark, which has not yet, but will ultimately be introduced into the record. So I'm just going to talk to you about this. And I will also point out that this is marked confidential, and that the table in particular is our understanding that the items listed under non-firm short-term energy and off-system sales revenue are considered confidential numbers. So I am not going to ask any question about those numbers. However, it is my understanding that the margin, which cannot be calculated, sorry, you cannot get to the confidential numbers from the margin. I intend to discuss those numbers now on the record without going in camera. And I am pausing here to offer an objection if somebody is concerned with that. All right.
John, like, it's all marked as confidential, so I just, let me check. Did someone tell you that? That's what I'm.
He's working on it already.
I think it'd be better to go in all confidential unless you can just talk generally about that margin number, John. I don't have the person here that would know.
If you would, I would ask to go in camera then. I'll try and keep this brief.
All right, let me, before we go on camera, let me verify if there's anybody in the room who is not cleared to be in the room. And I'll count on Brian to And Mr. Kleiser, when you're ready, sir.
And Mr. Raj, you would agree with me that in the absence of an FAC, those costs, absent some other commission order, would be borne by the company itself, correct?
Judge, I think we're getting beyond bench questions.
Mr. Kleiser.
Right. This questioning, again, comes back to the idea of what was actually at heart of the calculations being performed by the OPC. But honestly, I actually think I'm prepared to move on past that for just a moment. So I'll withdraw the question. Now, do you recall receiving a series of questions from Commissioner Holzman regarding the operation of Evergy Metro versus Evergy West and how they were? Do you recall those conversations?
We talked a little bit about the potential view of combination, I think. Is that where you're headed?
Yes. You would agree with me that right now for the SPP, and that's for the record, Southwest Power Pool, I think that might have been said before, but just for the record, Evergy West and Evergy Metro are treated as a combined entity for determining whether they are meeting the resource adequacy requirement.
Yeah, it's specific to that. It doesn't combine kind of the overall cost to serve or anything else. It's in measuring adequacy at the SPP, yes.
And how many employees does Evergy West have, separate from Evergy Metro?
Well, I haven't looked at the employee roster for a while. I'm not sure that West has any employees. Most folks, like myself, have responsibilities over a number of legal entities.
And with regard to potential for combining Evergy West and Evergy Metro that you were discussing with Commissioner Holzman, do you recall in the 2018 Evergy general rate case, the stipulation and agreement that was signed between parties, or at least generally recall that?
I mean, there's probably lots of stipulations in that case.
Fair enough. Let me dig down a little bit deeper. Do you recall Evergy agreeing to review combining Evergy West and Evergy Metro as part of a stipulation in the 2018 series of general rate cases?
I do, because I recall we also filed that report in 2020. I think it was October of 2020.
And I think you might have actually answered this same question with regard to the long conversation that was had. But when we talk about alleviating the gap in generation between what is produced and what is necessary, Evergy West is currently has potential increased load coming on too, correct?
Yeah, I think all of our jurisdictions do. We talked about that a little bit. There's a good environment for economic development in our states right now.
And I think that it's public knowledge at this point that Facebook is anticipating building a data center in the Evergy West footprint. Is that correct?
Meta is in, I think, Evergy West, and Google has announced in Missouri Metro, I believe.
And that data center would be expected to significantly increase the load that would be required to be met by Evergy West, correct?
Yeah, data centers are load intensive, yes.
So that would require even more generation to be brought on to meet that gap, right?
Yes, that's why you see some upgrades in our current period IRP for both, not only the load, but for the change in the SPP accredited capacity and capacity requirements.
think I have probably just the one last series of questions. In your conversations with the commissioners, you had discussed, Evergy following its IRP, its Integrated Resource Plan. Do you recall that?
I do.
Going to distribute another document.
No, that's all right.
Mr. Ives, what I've handed you is a copy from the existing Code of State Regulations. And I would draw your attention to subparagraph 17, which is at the bottom right of page 21.
I'm there.
And I'm actually going to start at literally the last 4 sentences of the page and then proceed to the next one. In proceedings where the reasonableness of resource acquisitions are considered, consistency with an acknowledged preferred resource plan or resource acquisition strategy may be used as supporting evidence, but shall not be considered any more or less relevant than any other piece of evidence in the case. Consistency with an acknowledged preferred resource plan or resource acquisition strategy does not create a rebuttable presumption of prudence and shall not be considered to be dispositive of the issue. Would you agree with me that I've read that correctly?
Yep, and I would agree that's the treatment.
All right. Your Honor, I did not anticipate admitting that because as a part of the Code of State Regulations, I expect that I can cite to it without its admission onto the record. So I have nothing to admit, and I am finished with my cross-examination.
Great, Mr. Kleiser, thank you. Any redirect?
Thank you, Judge.
Was this an extra copy? It wasn't yours, right?
Mr. Ives, I have just handed you what I will eventually offer as Exhibit 13. We understand this document is in response to Chair Hahn's request for data from the company and also relates to some questions about load that you've received from the bench and on recross. So can you please describe what this document contains?
Yeah, briefly, I won't go into a lot of specific details because these are confidential schedules, but these are 3 different views from 3 different time frames tied into our integrated resource planning that shows the capacity view of how EMW is meeting its load requirements at SPP for peak load plus reserve margin. So I know we talked a couple different times here about, capacity versus energy. I went through a couple of questions with Mr. Keevil about that. And I know Chair Hahn has asked OPC to provide the energy relationship. And I think it was important to also share the capacity relationship because energy can be affected by changes in the SPP market, right? Callability of a resource because of how it stacks up in the market at any given point in time. So even though you may have capacity, it may not get called and turned into energy in the market. It may be cheaper for customers to exercise their ability to go to the market for energy. So it's good to have both analyses of how we're meeting our capacity requirements for resource adequacy at SPP while you're looking at the energy analysis that I think OPC has offered to deliver later, and hopefully we'll all get a chance to look at before it goes into the record.
Okay, and Your Honor, so at this time, I would offer this exhibit as Exhibit 13, but confidential.
So I will label that as Exhibit 13C, and that has been offered. Any objections?
Your Honor, I don't necessarily believe that I'll be objecting to it, but I would make a request that parties be given an opportunity to review this more in depth and potentially file objections after the fact, and in effect treating it as a late filed exhibit, just to give us a better time to understand it in case we have objections, because I haven't seen this before. But I have no standing objection to its entry other than that.
Any response? Ms.
Judge,
Whipple?
we're all right with that as long, of course, as we're afforded the same treatment if the OPC offers any exhibit in response to the chair's request.
All right. Exhibit 13C is admitted. And Ms. Whipple?
Is it admitted or is it provisionally? If he's possibly going to object to it later, I wouldn't think you'd want to fully admit it with all the.
No, I agree. I mean, I guess a better way to say it is provisionally admitted pending possible later objections. I mean, I want to be, I want it marked in the record that we don't have any objections as of now, and so I'm admitting it with the understanding that somebody might launch an objection later. Okay. Yeah, and reminders to speak into microphones, please, for people on WebEx. Thank you. I'm sorry, Ms. Whipple?
Thank you. Mr. Ives, in your response just now and in other questions that you received from the bench and on recross, you discussed relying on the energy market and whether that's risky to customers or not. Could you summarize generally what the company's position is on that, since it's so important in this case?
Yeah, we talked about that, when I was speaking to the commissioners earlier. Probably good to reiterate. I mean, reliance, my perspective, and I think Evergy's perspective as well, is reliance on any one source to serve customers solely or primarily can create additional risk, right? Whether that be, relying on only natural gas-fired own generation to serve customers. If you have natural gas spikes like we did in this same review period, that would have not worked out well either. So having a balance is what we've put through our integrated resource plans over the years. That balance moves and ebbs and flows a little bit, but it includes purchase power agreements, includes, direct market access, both for capacity and supply. It includes, renewables that are owned. It includes dispatchable resources. There was a statement made earlier today that I had some testimony about, playing the lotto. And there's a rest of the story on that answer. It was an excerpt that was cut out and used. I mean, the rest of the story said just exactly what we just discussed. I believe, and this is supported by past commission orders, that a balanced resource portfolio is in customers, staffs, OPCs, shareholders, and other stakeholders' best interest, and it would cover all those pieces I just laid out.
Similarly, you received questions about having steel in the ground. How could having steel in the ground impact base rates versus FAC costs generally?
Yeah, I just talked about that a little bit in response to OPC's recross as well. You know, it's easy to look at one side of the equation, you know, a table that shows increased FAC cost and, you know, a difference in one utility's view to the other, but you have to look at the total cost equation, which I mentioned in that response. You have to look at what's in base rates for the infrastructure investment that supported the better FAC performance on Metro's side. And I alluded to this earlier, said it directly earlier to the commission, that, you know, if you look at all-in rates, Metro's rates have historically run higher than West rates, and it's driven by the fact that they have infrastructure investment for that type of generation that EMW doesn't have because it's been utilizing the market for part of its supply to customers.
Relatedly, you received questions about the hypothetical combination presented by OPC and the disallowance coming out of that hypothetical situation. Would that impact access to capital? What are other impacts that hypothetical and proposed disallowance could have if adopted in this proceeding?
Yeah, we spoke about that a little bit when I was talking to the commission. I mean, when you do a combination of utilities that have supported their customers in differing ways over decades, you're really just going to end up with a reallocation of cost. That means in the case where you're giving some of the supply capability from Metro customers to be available for West instead of accessing the market, that Metro's customers aren't going to have that available to sell into the market and benefit from, even though they've been paying for those assets for a number of years. You're reallocating benefits from Metro to West, and somehow you're going to have to balance that out at the time of combination to make sure that customers remain whole for what they've been asked to provide for over the years.
Thank you. No further questions.
All right, Ms. Whipple, thank you. Mr. Ives, thank you very much. You may step down.
Thank you.
I believe the next witness is Jordan Hull for staff. If you'll raise your right hand to be sworn, please. Do you swear the evidence you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you. You may have a seat. Mr. Keevil, when you're ready.
Thank you, Judge. Mr. Hull, would you please state and spell your name for the record?
My name is Jordan T. Hull, Jordan. Last name Hull, Hullo.
And did you cause to be prepared and filed in this case rebuttal testimony, which I'll tell you now has been pre-marked as exhibit number 200?
Yes.
And do you have any additions or corrections you need to make to that testimony?
I do not.
If I were to ask you the questions contained in that testimony, would your answers be the same today as contained therein?
Yes.
And are those answers true and correct to the best of your information, knowledge, and belief?
Yes.
Judge, with that, I would offer exhibit number 200, the rebuttal testimony of Jordan T. Hull, into the record.
Any objections? Hearing none, exhibit number 200 is admitted into evidence.
Thank you, Judge. I'll tender the witness for cross-examination.
Mr. Keevil, thank you. Any cross from the company?
No.
Mr. Steiner, thank you. Public counsel?
No. Thank you, Your Honor.
Thank you. Let me see if we have any bench questions. Commissioner Holzman? Hearing none, Commissioner Kolkmeyer, Commissioner Mitchell, any questions? All right, I have no questions, so Mr. Hull, thank you very much. Let me step down. Our next witness is Lena Mantle for public counsel. right, Ms. Mandel, if you'll raise your right hand to be sworn, please. Do you swear the evidence you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you very much. You may have a seat. Mr. Kleiser, when you're ready.
Ms. Mansell, can you please identify your occupation and who you work for?
I am a senior analyst for the Office of the Public Counsel.
And have you prepared or caused to be prepared testimony for this case, which has been pre-marked as, should be two? Is it 300? Yeah.
Probably in the 300s.
Right, 300. See, the problem is that I know that they were marked with the confidential and public designations. I had my list printed out, and then it disappeared on me.
I'm looking right now. I'm showing you have 300, 300C for Ms. Mandel's direct, 301, 301C for her rebuttal, 302, 302C for her surrebuttal.
That is exactly it. Thank you so much.
Very welcome.
So I will reiterate the question since I botched that so badly. Ms. Mansell, did you prepare or cause to be prepared exhibits 300 and 300C, your direct testimony, 301, 301C, your rebuttal testimony, and 302, 302C, your surrebuttal testimony, respectively?
Yes.
And did you have any changes you would make to those
Yes.
testimonies? Your Honor, I believe, I'm going to go on a limb, I think 307 would be marking this exhibit.
The errata sheet? Okay.
Yes.
Thank you.
Ms. Mantle, does this errata sheet correctly explain the changes that you would make to your testimony?
Yes.
Your Honor, for procedural standard, she can either go through and explain her changes, or I can just offer the errata sheet and allow parties to review the changes. Which would you prefer?
Well, offering is faster, but I'll leave that up to counsel if they have an objection.
I'm all for fast, Judge.
No objection at this time.
Okay, very good. Mr. Kleiser?
And with the changes made in this errata sheet, would your testimony then be true and correct to the best of your knowledge and belief?
Yes.
All right, with that, I would move for the admission of 300, 300C, 301, 301C, 302, 302C, and what I have currently marked as 307, the errata sheet.
All right, any objections?
None.
Hearing no objections, exhibits 300, 300C, 301, 301C, 302, 302C, and 307 are admitted into evidence.
And with that, I tend to the witness. Thank you.
Mr. Kleiser, thank you. Cross-examination, Mr. Keevil.
Not at this time, Judge. Thank you.
Thank you. The company?
Yes, Judge, thank you. Ms. Mansell, would you please pick a version of your direct testimony that's easiest for you to grab? I'm not going to be talking about anything confidential. And turn to page 4.
I am there.
Do you see the question that begins on page 4, line 4, and it asks, how then should the commission consider Evergy West's resource planning process as part of an FAC Prudence review case?
I see that question.
All right, and then the last sentence to your responsive paragraph reads, consequently, The incurrence of the cost of natural gas that will be passed on to customers through any given FAC is set in motion by the decision to build a natural gas generation plant that might have been put in place years earlier, just as the cost to fill up your car's gas tank today is dependent upon the decision you made years prior regarding what car to buy. Did I read that last sentence correctly?
Yes.
In relation to that car analogy, when would you determine prudence? At the time you bought the car or at the time you filled up the tank today?
Prudence wouldn't have to be determined on what I was trying to achieve.
I'm asking you that question, though.
It's according to whether, if prudence is, did I get a car that is comfortable to sit in? Yes, it is. Prudence could also be how much to fill up the gas tank. But if I had plenty of funds, then I would think it was plenty prudent to pay more for gas for my car. So it's according to what you're trying to do.
Well, Ms. Mantle, in your written testimony, you say just as the cost to fill up your car's gas tank today is dependent upon the decision you made years prior regarding what car to buy. So with your sentence there, when is the prudence determination made?
This sentence isn't discussing prudence. This sentence is discussing when is the cost felt. It has nothing to do with prudence.
Well, the question does ask about prudence. How then should the commission consider Evergy West's resource planning process as part of an FAC prudence review case? So I'm gonna again ask you, this car analogy in your written testimony in response to a prudence question is what I'm focusing on. When do you determine the prudence in that car analogy? When you buy the car or when you fill up your gas tank?
That car analogy has nothing to do with the prudence of Evergy West resource planning. It's just an analogy of when that the payments continue for many years even though you purchase the car. Just as when you build a CT or combined cycle or a coal plant, you continue to incur those costs going forward. You don't incur coal costs before the coal plant is built. You don't incur natural gas cost. And which one you incur depends on what you built and when you built it.
I understand that it may just be an analogy, but it's your analogy, and so I'm asking you the question that you haven't yet answered. When do you determine prudence in your car analogy?
I'm going to object in that I do believe it's been asked and answered.
It specifically hasn't been. She's refused to answer it, Judge.
Yeah, I think it's been asked but not answered, and I think an appropriate answer is I don't know. So I'm going to overrule the objection.
I don't know.
May I have her testimony to the question is that she doesn't know? Is that your testimony?
My answer is it's depending on what is your measure. What were you trying to achieve? If you were trying to achieve a comfortable car and you bought a big SUV, you're prudent when you fill up the gas tank. If your objective was to keep your total costs low, you weren't. And the decision that was made, that's a decision that's early on in the car buying process, and it's up to each individual. But that wasn't the reason for this sentence to be in that question.
Okay, Judge, I am so sorry about this, but the answer was I don't know, and then the answer went back to not being an answer again. So for purposes of the record, is your answer I don't know? Can we land on that?
The question is, when would the decision have been imprudent?
The question is, with your car analogy, which decision is where you determine prudence? When you fill up the gas tank or when you bought the car?
The decision is made when you buy the car. Now, you're asking a separate question, which is, where should imprudence be determined, whether at the time you bought the car or when you fill up with gas?
My question is, in the car analogy, when would you determine prudence? When you bought the car or today when you filled up the gas tank?
I don't know.
Okay, thank you. Ms. Mantle, have you read the original position statement that was filed by staff in this proceeding prior to the stipulation?
I think I have. I really don't remember much about it, but I do believe I read it.
Okay. Could you please grab, I give you both of them, could you please grab the original position statement, not the amended one?
I have it here.
Okay. Your Honor, I'd like to offer this as Exhibit 14.
To be clear, it's the staff's original position statement, is that correct?
That's right.
It's been offered as Exhibit 14. Any objections?
I do object, Your Honor. I don't know what the evidentiary value of this is, considering that it's merely staff's position in this case, which is, for the record, already part of the record because it was filed in EFIS.
Well, it's up to you, Judge. We could do judicial notice of this as well, and it would have whatever weight the commission chooses at the time it's determining all of the evidence. If it's easier to enter it into the hearing record, that's up to you.
I mean, I think it's 6 of one, half dozen of the other. I mean, I can admit it into evidence, or I can take judicial notice.
Well, Your Honor, I continue to object to it being admitted into evidence as it is not evidence.
I'll take judicial notice of the staff statement of positions then.
Okay, thank you. Would you please turn to page 7? And please orient yourself to the issue. Should the commission adopt OPC's proposed ordered adjustment of $86,376,294 with interest to be applied in Evergy, Missouri West's next FAR filing? Do you see that?
I see that.
And do you see that staff's response to that issue question simply states no?
I'm going to again object. I don't understand why including the now amended position of statement of positions from staff moves the evidentiary needle at all.
Ms. Whipple?
It clearly has relevance to the issues in this case. It relates to staff's position, and whether the commission weighs it one way or the other is up to the commission.
Right.
Judge, I would,
go ahead.
since this was my client's position statement at one time, apparently before I became involved with this case, I would point out that this is not on behalf of any witness in this case. This was on behalf of the then attorney for the staff, and there is no citation to any of the record evidence in the case supporting the word no. So I don't see I don't even think this rises to the level of evidence.
That is my objection as well.
I'm going to overrule. I mean, I'm going to let her answer to the extent that she knows, and obviously don't want to simply read from position statements, especially since staff's amended its position statement later, but I'm going to overrule.
I can't, I'm so sorry, I can't remember if you answered my last question. You see that that issue is answered with no?
Yes.
Okay. As everyone has pointed out, could you please turn to the amended position statement? And Judge, consistent with your last ruling, I would ask for judicial notice of this one as well.
So taken.
On page 1 of that statement, could you please orient yourself to issue question 6, which states, was Evergy Missouri West's continuing decision to not acquire sufficient generation to protect its customers from the risks of the energy market and instead to rely on the energy market to meet a substantial portion of its customers' load requirements imprudent? Do you see that?
I see that.
Do you also see that staff's response is, staff agrees that Evergy...
Your Honor, I'm sorry, just to, before she cuts you off, I'm going to reiterate my objection on the grounds that this is not evidence.
Judge, I don't think that's a proper objection. I've never heard of that sort of a thing before, but even if it were, this does get into citation of record evidence that I'm going to get into next. So if I could just be allowed some leeway here.
Okay, I'll overrule. Thank you.
Do you see that staff's response is, staff agrees that Evergy Missouri West has relied on the market at times to meet its customers' energy needs. However, staff does not consider this to be imprudent and is unsure of what a reasonable disallowance would be based on the number of variables that would need to be considered when trying to quantify such a number. Do you see that?
I see that.
Do you see that that response contains a footnote? And the footnote cites the rebuttal testimony of staff witness Jordan Hull.
I see. That's what the footnote says.
Have you read the rebuttal testimony of staff witness Jordan Hull, which has been entered as Exhibit 200?
Yes.
Do you have a copy of it in front of you?
No.
Oh, I can supply her one.
Do you have one, John?
I have it.
I now have a copy.
Could you please turn to page 2?
Okay.
Do you see the question, page 2, line 4? Does staff agree with Ms. Mantle's direct testimony?
I see that.
Do you see Mr. Hull's response, which states, partially, staff agrees that Evergy Missouri West has relied on the market at times to meet its customers' energy needs. However, staff has not alleged this as an imprudent decision in this case. Further, if imprudence was alleged, a quantification of the disallowance associated with it would need to be provided. Ms. Mantle points out that there are many variables and that it is a complex optimization of many forecasted variables, including future market prices, the impact of demand-side resources, and customer load requirements to meet customer load, and she is right. That is why staff does not agree with her proposed disallowance. There are too many variables that determine not only the market price, but also how much is purchased from the market by Evergy Missouri West, as well as different variables associated with building new generation. Did I read that correctly?
Yes.
Also, on page 2, do you see the next question that says, Has OPC brought this concern up before?
That is what the next question says.
And then the response is yes, according to Ms. Mantle, it's been brought up 10 times in various case types. Do you
That
see
is what
that?
it, yes.
Okay. And then do you see the next question? Has the commission ever viewed this concern as imprudent?
That's what the question says.
And then do you see the response not to staff's knowledge?
That's what he said.
Okay. Now, if you'll please turn back to your direct testimony. Page 16. Are the case captions listed on lines 12 through 15 on page 16 of your direct testimony the cases that Mr. Hull's testimony was referring to?
I would guess so. You'd have to ask him.
In the cases that are listed there, it's true that the commission has never found Evergy, Missouri West resource planning to be imprudent, right?
Not in these cases.
And in these cases, the commission never made any disallowances based upon OPC's concerns raised therein, right?
Many of those cases, there could not be a disallowance made. Some of these cases, it was just that we filed testimony that it was imprudent, but these were not the proper cases in which an imprudence adjustment could be made.
So no disallowances, right?
Not for resource planning.
Okay, thank you. No further questions at this time.
All right, Ms. Whipple, thank you. Let me see if we have any bench questions. Commissioner Holzman.
How much do you estimate that Evergy West would have to invest in, generate to cover that insurance that we've been talking about all day? What's the shortfall?
There's different types of units that can be built, and some are expensive to build and cheaper to run, and some are cheaper to build and more expensive to run.
Would you recommend PPAs then to manage the shortfall?
No, PPAs are good in the short run. What happens is when you put a new generation unit in rate base, so initially it's very high, and customers have to pay a return on that. And a PPA is typically a flat amount. I mean, in the past when they were long-term PPAs, it would be a flat amount, and it would be below that amount that's going into rate base. But as rate base goes down, then putting a plant in rate base is cheaper for the customers, and it provides that insurance that a PPA, once that PPA ends, the customers have nothing. It could be a 5-year PPA on a 30-year plant. After 5 years, the customers don't have access to that anymore. Another PPA would have to be entered at another price.
So do you have an idea of how much accredited generation Evergy West would need to get to that 100%?
Again, accredited generation of a peaker. Let's say you put in 4 peakers that are 75 megawatts. You cannot get the energy from those that you could from a 200 megawatt combined cycle, because the combined cycle runs all the time. Peakers are built to run for very short periods of time. So they're cheaper to build, expensive to run, and they typically aren't, they only come on the market, they're bid into, as Mr. Ives said, to cover their variable costs. So they aren't run very often. Those
Would you
market
consider
prices have to be
dogwood
high.
what would you consider dogwood then? I mean, it's a peak plant. It can turn on for peak loads, right? But it's not.
It is a combined cycle plant. Now, what that means is you have combustion turbines, which are peakers, but then you also have what's called a HRSG, heat recovery steam generator, that takes that excess heat from those combustion turbines and uses that steam to generate more electricity. That's why you will find combined cycles running quite a bit when natural gas prices are low, because having a combined cycle, that HRSG, really increases the efficiency of those plants. And when natural gas prices are low, running those plants is sometimes less costly than running a coal plant.
So do you have an idea how many megawatts you would recommend them investing in to make 100%?
I will tell you, that's the reason we have resource planning. There's so many variables. It's this big linear programming problem. You've got all these types of inputs, and it's not a simple problem. That's the whole reason.
Could you ballpark it? Could you say they need another 750 megawatts to not have this problem? They need another, could you ballpark it?
I really hesitate to do that because, for one thing, I don't want Evergy West to go out and say, well, OPC thinks we ought to build 750 and it's real expensive, and then it gets put back on. Currently, they have a contract with KCPL for capacity. I don't think that number is confidential. Is the number, the capacity amount, the contract you have with Evergy Metro, is that confidential?
Can you not say it then? We're not sure.
Commissioner Holzman, I would like to say a number, but that amount. It would be on the this Exhibit 13C, if you, that Evergy West entered. And if you go to the last page, and I won't say the number, let's see.
Is this of your testimony?
No, this is an exhibit that Evergy West 13. Okay. It's confidential, so I won't say the numbers.
We're on the last page.
Yeah, this shows for 2024, 25, and 26, more or less their capacity balance, what they're going to use to meet the SPP requirements. And if you go down about 2/3 of the way, I know the print's really small, it says capacity only purchases. And there is an amount there.
Okay, I gotcha. Yep.
Now that would get them.
Is that in megawatts or is that in?
That is in megawatts. I have not seen that before today, but that's how I would read that. That would be an amount a minimal amount. And as to what type, based on my experience, I would say a combined cycle plant, something that can be dispatched, something that runs efficiently.
So approximately the size of a dogwood an additional dogwood would get us close.
Okay, dogwood is actually 645 megawatts, I think. Their piece.
300.
While you were gone,
yeah.
Mr. Eyes was still up. He said he was wrong on the 300 and that it was actually closer to 140.
The dogwood is closer to 140.
Their share.
Oh, their share of it is 140.
Yes. And you saw on that graph that was in our opening how very little that really moved.
Right.
So
I'm just trying to get to an understanding of how much you think they need in extra capacity right now to have the insurance necessary to not be subject to the volatility.
I would say at a minimum at least twice what they are purchasing from from at the capacity contract. And that's just based off, I haven't done analysis.
I'm just looking for a ballpark.
I would say that's a minimum.
Okay. So is it safe to say that in future proceedings, OPC is going to be supportive of generation investments by Evergy West? Is that safe to assume that's an extrapolation?
I cannot speak for OPC, but I would advise the public council that, I mean, of course, prudence of cost, prudence of building, where it's built at, so forth. But yes, just as we were supportive of acquiring a piece of dogwood.
What about, I know OPC has sometimes been reticent to support emerging technology. You know, if we're looking at battery storage for renewable energy, we heard a report in the agenda earlier that the EPA greenhouse regulations are going to require some carbon capture and storage. We all know that oftentimes emerging technology may not be least cost. And so sometimes OPC has been resistant to supporting investments in emerging technologies because they don't always meet the least cost factor. But if we're going to get the utility companies to a place where this technology becomes viable, there's going to have to be some sort of initial investment. So given the fact that you're making the argument today that they don't have enough generation, and we know that with these new EPA rules that we've heard about earlier today, that these are going to require new construction of gas plants, do you envision OPC maybe taking a nuanced approach to investment in the future that may try to get to the solution that you say is lacking today?
The Commission's own resource planning rules say that legislative mandates and legal requirements should be met. If they have to meet those, and the only choice is new and emerging, I don't see why OPC wouldn't support that.
Okay. Thank you. Thank you, Judge.
Commissioner, thank you. Any further bench questions? Commissioner Kolkmeyer, Commissioner Mitchell, any questions? All right, thank you. I have a few questions. Are the references in your testimony, Ms. Mantle, to EO 2023-0291, should they be EA 2023-0291, or are these two different cases?
They're the same case. I just got the second letter wrong.
I understand. Do you have Ms. Messamore's direct testimony available?
I can ask my counsel.
Certainly. Mr. Kleiser, thank you. And Ms. Mantle, could I direct you to page 15 of her direct testimony? And I believe specifically lines 10 through 12. And if you'd let me know when you're there, please.
I'm there.
Okay, thank you. Do you agree with Ms. Messamore's testimony there that OPC's recommended disallowance does not include the inverse impact on Evergy, Missouri Metro?
Our recommended disallowance had no impact on Evergy, Missouri Metro. What that would be doing would be putting the disallowance on Metro's customers who did not make the decisions, who did not have any part of this. So, and by just moving it to Metro would mean that there's, there was no Prudence disallowance to Evergy because they'd just be collecting it from a different set of customers. So we never mentioned that Evergy Metro's, we never thought that Evergy Metro's customers would be making up that difference.
Okay. Could I direct you to page 8 of your direct testimony?
I'm there.
Okay, thank you. I think on page 8, you testify that the prudent utility does not build to meet the RTO planning reserve margin, but meets the RTO planning reserve margin because it builds with a margin that will ensure it is able to meet its customers' needs. Is that, in a nutshell, the fundamental issue that Public Counsel has with Evergy Missouri West?
Can you tell me what line? That sounds like something I would say. so-
Okay, maybe it's on Schedule LMMD3, I'm sorry.
Okay, which paragraph? Or where in that?
And my notes are that's on page 8, maybe of Schedule LMMD3.
Where I talk about the type 1, the prudent utility?
Yes.
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 Now, what part, I'm sorry.
That's quite all
Can
right.
you tell me,
It is a way to, I guess, to characterize the fundamental issue that OPC has with Evergy Missouri West is, and let me go through the statement again. The prudent utility does not build to meet the RTO planning reserve margin, but it meets the RTO planning reserve margin because it builds with a margin that will ensure it is able to meet its customer needs. Is that basically the issue that the Public Counsel has with Evergy Missouri West?
yes, a prudent utility should come up with the cost-effective way to meet their load. Because that's when, the costs that they are charged from SPP is when their load requires energy from SPP. So if you have the energy, if you have the right type of capacity, the right type of generation, and it's efficient, cost-effective, it's going to run when that load is happening. And those two are going to offset itself. Within reason, there's transmission congestion. SPP market's not that simple. But if they have cost-effective generation at that point in time, the customers would be left paying was the fuel for that, because what they received from the market would match what they were charged by the market.
Does OPC consider Evergy Missouri West to, for lack of a better term, be mooching or sponging off of maybe Evergy Missouri Metro?
And that's my term, so, but not just Evergy Metro, it's whatever resources are being offered into the market, and most likely Metro, because it is so close and because it has a lot of cost-effective generation.
Would you agree that a recent addition of Dogwood to Evergy West fleet is a step in the right direction to address OPC's concerns?
It is a baby step.
With that Dogwood addition, how much capacity would that add to Evergy West fleet?
Well, they say it's 143. It is not 143 until, I think, 2020. It goes up to 70. They actually get 76 in 2027. They don't get the whole 143 until 2029 because Dogwood had entered into a capacity contract with a different party for the capacity. So Evergy West will be getting the energy and the revenues from the energy, but they don't have the capacity until that capacity contract ends.
And I think one last question, and towards the end of your direct testimony, I think on page 19, you kind of go through your calculation to arrive at OPC's recommended disallowance. Why is your calculation a reliable method for quantifying that disallowance?
As there's been a lot of testimony filed about, and even my conversation with Commissioner Holzman, how hard it would be to come up with what my definition of prudent resources to add and cost to use could be just as prudent as yours, and which one's the right one? I mean, and since that was so difficult, I at their IRPs, their resource planning. And as far back as I can remember, the resource planning presentations, they say, here's Evergy. Oh, and here's Evergy West, and here's Evergy Metro. And now we're getting Evergy Kansas in those same analysis. And while they say they're not combining them, they are taking them into account. And when, and as evidenced by, Evergy Metro will be getting shorter on capacity as these new data centers are built. That's when we're starting to see building being done for Evergy West. They may say they don't do joint planning, but everything that I see, and even in their conversations, shows joint planning to me. And so for that reason, and because I have the data for Evergy Metro, and their IRPs are their FACs are almost identical. I did remove an SO2 amortization out of Evergy Metros because that's money that comes back to the customers as part of the IA-10 2 build. So when I combined, it was saying if they were one utility, these were the costs they would have incurred. So that is, those numbers were real. Those numbers occurred at the same weather, the same time, the same market. And it's a very reasonable and real number. And then looking at that 193, the difference, the Prudence adjustment, it again didn't seem right because we knew that Evergy West customers had not been paying for the capital cost that Evergy Metro customers were. So we went back to the last rate case and pulled out how much the total cost of those Evergy Metro's plant cost was and allocated that between the two also. That's how we came up with the, I think it was 78 million, to get the total number down to 86 million. So taking into account that, yes, over time, Evergy West customers would have paid more in their regular rates had they had access, if they had acted as one utility instead of two.
All right, Ms. Mantle, thank you. Those are all my questions. Any further bench questions?
Your Honor,
Mr. Kleiser.
during the opening, there were several questions posed by the bench, and at the time I had deferred them to Ms. Mantle. We have since attempted to answer those questions. Now, I appreciate that the bench may no longer have those questions, but I just wanted to let them know that we had developed the answers to those. For example, what would it look like if the two utilities had been combined, and what percentage of the requirement was met with generation? So just wanted to throw that out there.
All right, thank you. I appreciate that. If there's no further bench questions, any recross based on bench questions? Mr. Keevil.
I think I have just one, Judge. Ms. Mantle, in response to the judge's last question, you were, in part of your answer, you mentioned looking back at the company's IRP filings and using that as part of your basis. And I believe there were other questions regarding resource adequacy and resource planning. Well, let me back up a little bit. Were you involved in writing the commission's IRP rules?
Yes, I was, both in the original writing and the revision that occurred and became final in 2012.
Okay. There's been a lot of discussion today about the IRP and what did or did not happen in various IRP filings. What is your understanding of the intent behind the IRP rule as it currently exists in Missouri?
Prior to the drafting of the resource planning rules, the utilities had just added a lot of coal generation and the 2 nuclear plants came online. And the reason that happened was because, and at that time, they didn't have computers. They drew a straight line and said, well, the usage is just going to continue to skyrocket. And the commission at that time realized that was wrong, because once everybody got an air conditioner, they didn't put 2 in their houses. So once residential saturation, air conditioners hit almost 100% saturation, the load forecast didn't grow as much. So the commission set their research and planning department to looking at what kind of information did a utility need to look at to come up with a good resource plan. And if you look at the rules, there's all kinds of load forecasting where you need to look at how your customers are using electricity. The resource plan also requires the utilities to look at risk. And knowing that all the inputs are the utilities, and it's a modeling exercise, but the idea was if a utility had good data, it would make better decisions. So that's the reason. It's really, at the time, there was a lot of discussion on, do we do pre-approval, do we not? The utilities not too surprisingly wanted their resource plan approved so that anything they put in there could be prudent, could be considered prudent. And there was a lot of legal wrangling over what should be done, and what we have in the rule is the final decision of the commission. And that was hassled over again in 2012 when we revised the rules. And what has come out in the final rule is the determination of the commission at that time.
And does the commission in the IRP cases, does the commission conclude those by finding the utilities plan to be prudent?
No. As specifically as read by Mr. Ives in response to a question from my counsel, the rule says it is not approval. There is no pre-approval, or there's no approval of a resource plan. The commission can say it's reasonable, but there's no approval of the plan.
And what's the language about, I'm going by memory here, something about acknowledgement, or the commission acknowledges, or can acknowledge, but doesn't have to acknowledge, or what am I thinking of there?
That is correct, and I don't have the language directly in front of me either. But typically what the commission says is they've met the requirements of the rule. That means they've gotten the data that's been required, they've looked at it. It's not that the commission is saying this is a good plan, go forth and build, or not build, but it's the commission is saying you've met the requirements of the rule.
Okay. I think that's all I have, Judge. Thanks.
Mr. Keevil, thank you. I do think we have some further bench questions. Commissioner Kolkmeyer.
Yes, thank you, Judge. Earlier this morning, Mr. Kleiser had his last slide, okay? And I was going to ask him the question, and I held off for you. And maybe Commissioner Holzman asked this question maybe in a little different way. Mr. Kleiser, do you have your back page? I thought I had your presentation right here, but it was the 2 lines showing Metro and West, and then, yeah, it's
It's not that one. It's I know which one you're talking about. Unfortunately, I don't have a copy of me.
Okay, and I apologize. I thought it was the back page, but anyway, I talked about averaging those 2 out or combining the 2, and as Mr. Isles said, it would take years to do that. It'd be quicker to build than it would be combined. But if you average those 2 together, it almost looks like it would come close to, yes, thank you, this one. If you look at this, it would come close to averaging out, would it not, if they combined the 2?
Commissioner Kolkmeyer, I came up with that graph during lunch.
This is your graph.
I did not, the graph that you requested with those two combined.
Okay.
Do you,
A bit unorthodox, but I would move to mark an exhibit to help her respond.
That is fine with me.
That graph does exist.
I created it at lunch for you.
Ah, you knew that question was coming.
I gave him my copy.
She handed me one.
I believe we're on Exhibit 308. Thank you.
Now, what I did was, I combined the generation for both Evergy West and Evergy Metro together, and I combined their net system input, which is what is the requirements of their customers for each one of those months. And then you can see down here, the red is Evergy West, the green is Evergy Metro. The blue line that runs pretty close to 100% is what that would be if they were one company.
Okay.
So it is not smack dab down the middle.
No.
Because Evergy Metro is a larger utility. Evergy Metro covers both parts of Kansas and parts of Missouri. And what I used here was the total company because the generation is not Evergy Kansas and Evergy Missouri Metros. The generation is Evergy Metros. So to get the right comparison, I included the entire amounts. And that's why you'll find the blue line closer to the green line than the red.
Okay. Thank you.
Again, not to interrupt the bench questions, I would move for the admission of 308. I would move to have it admitted as a late filed exhibit subject to objection by opposing parties, as was the prior Evergy exhibit.
308 has been offered. Any objections? With the caveat that parties be allowed time to late file objections if they would like.
Given the caveat, no objection at this time.
Okay, very good. I'll as I did with a prior exhibit, I believe 13C, this exhibit 308 is provisionally admitted with the understanding that we might get some late filed objections later. Okay, thank you. Any further bench questions for Ms. Mantle? All right, recross based on bench questions. Mr. Keevil, any further questions?
No, Judge.
Thank you. From the company?
No, thank you.
All right, any redirect?
Yes, please. Really quick, just before we get anything else out of the way, you mentioned briefly KCPL in responding to a question. Can you identify what that is for the record?
KCPL is a predecessor to Evergy Metro.
And it stands for?
Kansas City Power and Light Company.
Super, thank you. You were asked a series of questions regarding the prior cases that we had brought up this issue in questions from Evergy Council. Do you recall that?
I recall that.
And first of all, you identified that some of those cases, there was no imprudence disallowance for a reason. Can you elaborate on that?
Like the very first one, EO 2017-0230, and Mr. Ives read in parts of our comments to that resource plan. There's no method of finding for imprudence. It was a resource plan. And that is our role in the resource plans. When we find something we do not believe is right or good, we're to bring that up. That there is no decision to be made by the commission on those. Same for the contemporary resource issue, the EO 2018. That's where we bring it up and say that the company should look at that. So there's not necessarily, in a lot of these cases, a reason, or the commission can't make the disallowance in these cases. the FAC rate change case, ER 22-0130. It's a rate change case. It's not a case in which you make adjustments due to prudence. It's not the reason for the case. So the FAC prudence cases are the correct place to do that.
But Evergy counsel is correct that there are several cases where we've brought this argument and the commission has not ordered a disallowance. That's an accurate statement, right?
Yes.
And can I ask you, in your experience, having worked on resource planning for as long as you have, what impact has that failure to find a disallowance had on Evergy's resource planning?
They've continued the status quo of not, the only generation that they've added have been wind PPAs, which due to their nature are only called on to generate when the wind is blowing. And there's so much wind in the SPP that there's not a lot of revenue created from that, and that's part of staff's case. And these are expensive PPAs. That's a generation that Evergy West has added. They did add a piece of Iatan 2, and since then there has been nothing. So there's been no move to dispatchable type of generation, and they haven't seen a need to because they have an FAC. They can flow the market purchase prices through to customers. They can bring on PPAs between rate cases, flow those costs through to customers without it even going before the commission.
And in that same vein, you were asked a question from the bench regarding, why our calculation was the best option. And I would ask you, again, based on your experience, what will happen moving forward if the company doesn't receive a disallowance?
It's likely to continue to rely on the market because that's the least risky path for the utility.
Why did you sounded like you were caveating that for the utility. Is there a reason?
Judge, this line of questioning obviously calls for speculation.
Mr. Kleiser.
Oh, I was just asking her to explain what that last part was, but I can move on.
Thank you.
I think you already answered that question. With regard to kind of the dialogue that you're having with Commissioner Holzman, is there another witness provided by the OPC who can speak to those issues?
Yes, Dr. Jeff Mark.
And early on, you were asked a series of questions from counsel from Evergy regarding a portion near the beginning of your direct testimony. Do you recall that?
Yes.
And I think part of the problem that was involved in that was the issue of harm. How does harm play into the question of when you bring a imprudence or disallowance for imprudence?
A decision can be imprudent but not cause harm. And this commission has typically, and I've been around 40 years, I'll go ahead and say it, and I have never known it to find imprudence when there hasn't been harm. There's no reason to. And I do know of occurrences where there was imprudence, but there was no harm to customers. So there was no reason for staff, the instance that I'm thinking of, to bring it forth. So what's important, imprudence without harm is imprudence, but this is imprudence with harm.
I have no further redirect. Thank you.
All right, thank you, Ms. Mantle. Thank you very much. You may step down. Although this is kind of a natural time for a break because we're making ground, I would like to call Dr. Mark to the stand, and we may take a break during his testimony, depending on the length of the testimony. Yes, this will be our last witness. And if you'll raise your right hand to be sworn, please, sir. Do you swear the evidence you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you very much, sir. Please have a seat. Mr. Kleiser, when you're ready, sir.
Dr. Mark, can you please state who you are employed and by what capacity?
The Missouri Office of Public Counsel as the chief economist.
And did you prepare a cause to be prepared pre-filed testimony, which I'm hopefully is 304 and 304C, the surrebuttal, both public and confidential versions?
Yes.
303 and 303C. Yes, you answered yes to that question. You've caused to be prepared your surrebuttal testimony.
Yes.
Are there any changes you would make to your surrebuttal testimony?
No.
And if I ask you the same questions contained therein, would they be true and correct to the best of your knowledge and belief?
Yes.
All right. With that, I would offer 303, 303C, the surrebuttal testimony of Dr. Jeff Mark, public and confidential, respectively.
Any objections?
None.
And I'm sorry, Mr. Kleiser, that was surrebuttal?
Yes. Dr. Mark only filed surrebuttal.
And that's 303 and 303C. I'm hearing no objections. So 303 and 303C are admitted into evidence.
And I tender the witness for cross-examination.
All right, thank you. Any cross? Mr. Keevil?
No, thank you, Judge.
Any cross from the company?
No, thank you, Judge.
All right, any bench questions?
Just briefly.
Mr. Holzman?
Thank you. You heard the exchange that I had with Ms. Mantle. Do you agree that we're looking at approximately the number that was in that confidential statement of what Evergy West is short of in order to meet its goal?
Yes.
Okay. What would your, if Evergy West decided that it was going to take a non-conventional route, we talked about VPPs in the past, if the, I guess let me ask it another way. Let me backtrack a little bit. Do you count customer generated power that's net metered into this? Because they're not, can they sell that power into the RTO?
No.
What's that?
No.
No, they cannot.
Right.
So it's not considered a part of their capacity.
So if I may provide a little context for that. Yeah. So as I understand the question that you're asking for, and I'll get to the VPPs and net metering in particular, but we're talking future tense, how to move forward with this as opposed to the past tense issue. I would say that OPC, first of all, just make the observation, it's been about 2010 since we built anything. So let's just pause right there for a second. We've shut down stuff in the intermediate period, but of the 4 electric utilities that we have, only one utility's seen load growth since 2010, Evergy West. Unfortunately, Evergy West is the only utility that had shut down power too.
And that includes no wind, no solar, no generation at all?
They have put on power purchase agreements. They haven't built the wind. The company came in to ask, to purchase Persimmon Creek, and I know staff and OPC both objected to that. But that was largely based off of wind eating itself in the market. You hit a point of diminishing returns that the wind that's being operated during that hour is being operated by other wind, right? So, and it's also happening at, the middle of the night, these sort of things. And the historical performance of Persimmon Creek. So that is a concrete example where we did object to it because we didn't see the benefit in it. We haven't objected to building anything else. I would argue and you can look at our special contemporary topics, which is something that I personally take very seriously because we tee up so many topics for the commission to go ahead and say, yeah, model for this, including VPPs. That has been our issue. To speak about VPPs, just real general here, and Evergy really does have an incentive to push forward. There is a route where that makes sense to move forward with that. But the reality of it is our solar penetration in Missouri is razor thin. Like there's just not enough rooftop solar. Like even if we just had a magic wand and we gave everybody that's got rooftop solar right now a battery, I mean, it's not going to move the needle. And then there's obviously costs that are associated with that. Could I see a world where solar drops and all of a sudden this happens? I don't think nobody said this statement, but the reality of it is November is going to have a lot to do with that. you know, right now, you just heard David Campbell get up here and talk about all of the environmental costs that are associated with fossil fuel and bringing on new fossil fuel. You know, in the same week, the Biden administration has leveled extremely high tariffs on solar panels, on precious minerals, on EV cars, all of that. It's going to make doing either one difficult. The only thing I can confidently tell you, and we're wrestling with this right now, is we've teed up a bunch of IRPs, and I say we, like we collectively, staff, all of the companies, is how to comment on these IRPs when we know they are going to categorically change come November. Like we're going to get a little bit of a better sense, and it's not going to be an immediate thing because writing a path-dependent, large capital-intensive utility in a different direction takes time. You know, our concern, and we've leveled this, and we hear, you know, in the IRP they're planning on doing this and this. My sort of sanity check for that is, well, is it in the interconnection queue? Because until it actually goes into the interconnection queue, and it's a long line, right? Everybody's trying to build, they want to move their stuff up, and there's only so many people at the SPP that can actually do this. You can't look at everybody's queue and there's, you know, articles about how long those lines are. Right now, there is nothing in the queue for a natural gas plant. It's in their IRP, but it's not in the interconnection queue. And that's the sort of stuff that gives us heartburn. That's the sort of stuff that gives us heart palpitations, and why we've been saying this for years. You know, whether it's in the IRPs, whether it's in a rate case, whether it's special contemporary topics, we have said, hey, combine both utilities. We stipulated to it. You know, we put up our own outside consultant to go ahead in 2018 to make a case that we do everything else. SPP recognizes these two utilities as one entity for capacity purposes, not energy purposes, but for capacity purposes. For MIA, we do the exact same thing. In the last MIA case, we had Evergy West. It made sense to do a MIA. For Metro, it made no sense. Well, let's combine the two. You know, so this isn't like unprecedented. Like what OPC is putting forward, whether it's combining the utilities or combining the utilities in this hypothetical that comes across very reasonable. So would OPC to try to, you know, full force, like, you know, do I agree that they need to build? Yes, we need to build. I think that's true for all of our utilities. And there's a lot of disagreement as to exactly what that means moving forward. And I go back to
Do you agree that 2029 is the earliest that building could occur?
No. You know, so, I mean, there's a handful of things. What I agree with Mr. Ives in a measured, all things being equal, I agree that there should be diversity in our portfolio. I think that's a good hedge. Have a little bit of everything. You know, don't get so resource dependent where we're just on one thing and then we're exposed to the whims of the political winds. But that really does include looking at everything. And, you know, there are so many different options to consider. You know, this isn't going to be a popular response, but time of use rates were one. I mean, that was an issue where we could help meet our resource needs. And we've pushed back off of that for reasons that I completely understand. But moving forward, from my vantage point, if I'm providing, you know, context for all this, I mean, you look at everything. Building generation moving forward is going to be highly dependent on how quickly the transmission lines move forward at the federal level with FERC. We know there's going to be pushback at the state level. That is going to stall things out. What I think we're trying to get across here, though, is right now it's skin in the game, and the risk exposure is entirely lopsided to ratepayers, and it's been entirely lopsided to ratepayers, like on a going forward basis. Every 18 months, we're losing money, hundreds of millions of dollars of money, and that's where the insurance argument really does come full force. Because if I'm insuring, if my house burns down and I don't have insurance, man, that's awful. I mean, that's on me. If my house burns down 6 times in a row, maybe that's really like the issue at play here. But the utility isn't exposed to that risk. They're not eating those costs. It's being flown right back into ratepayers. And, You know, just again, with the period that we're talking about here, you could have built a lot with $1 billion.
If they had done what you had suggested them do in 2017, let's go back to that point,
Sure.
and Uri happens in 2021, right?
Right.
Would the impact on ratepayers, that 300 million that was securitized, would that have been different?
Yes.
Do you think?
Absolutely. Metro made money. I mean, then we got the graphs to show it. I mean, like, Metro is making money. And I get it, like,
So all our utility companies in the state, our regulated utilities, they earn a return of and on when they invest new.
yes.
So what, if OPC is saying we need to build new, and they're gonna return of and on, what do you think the reticence is for, why do you believe that the state, all of the utilities, not just the one in question here, why are we not seeing construction from all the utilities and at least getting in the queue, getting ready to build?
I think you're seeing that with Ameren. I think Evergy is a unique situation, and I think context is important here. If you look at what has gone on with this company over the last 5 years, we had a failed merger in Kansas initially. That set the company back another year, 2 years. There's cost associated with that, there's opportunity cost associated with that. We had an aggressive investor, activist investor, Elliott, try to take over the company because they weren't investing, because they weren't doing a whole variety of reasons were the accusations. And I'm not saying I agree with Elliott entirely on this, but there were a lot of extraneous factors that have played into their capital investments. And even moving forward, we teed this up in the PISA announcements, they're planning on spending close to $4 or $5 billion over the next 4 years, I think is what they put in their last option. They also got, very favorable legislative treatment over in Kansas last year. So how much of that's going to go into Kansas? How much of that's going into Missouri? I don't know. How much assurance do I have with that PISA plan? Honestly, probably not a lot now, because, the metrics have effectively changed. So if they had consolidated back in 2017, and I get it, like it is unbundling the Kansas situation in Kansas City, we wouldn't be here. It'd be a different situation. And our big concern is, absent a commission order or some sort of directive, this next FAC period, you're going to see the same impact, and the next one, and the next one. Because do I think the market's going to get more volatile? I do. Okay.
But minus consolidation with a 2029 runway for new construction, we're going to have FAC cases before that. So you're correct in saying that the insurance isn't going to be there at the earliest, unless they do PPAs, until 2029, according to the company themselves. So, I assume we'll have the same conversation.
Yeah, I mean, largely.
And we heard the consolidation couldn't happen for another 5 years. So there's no exit ramp here that's going to fix this problem. But I'm not sure, so I'm acknowledging that, but I'm not sure that is the same thing as making a case that what's led us to here is both imprudent and harmful. So I understand what you're saying in terms of where do we go from here, but I don't know, I'm still trying to, hear evidence that what has occurred in this FAC period has actually caused, that volatility has caused harm to the ratepayers.
So, I mean, that the response to that is, we use a reasonable man argument. What was known at the time. And, I would highly encourage you, it's not particularly long, just to revisit my rebuttal testimony where I go into length about this. What would a reasonable person, knowing the information that was available at that time, what did we know? We know that we have continuously had our house burned down. We're continuously losing money. We know that we are continuously relying on Metro to go ahead and meet our capacity, but not our energy. We know that the SPP market is shutting down fossil fuels. And it is getting more volatile. We know that in Texas, we had a proxy example of a market we called, it was a utility called Gritty, that was completely wholesale. That is the equivalent of like full risk. The company got sued by the Texas Attorney General. It went bankrupt. I mean, a reasonable person would sit there in my mind and be like, we're bleeding. Let's stop the bleeding. Let's do something proactive. But it's ratepayers that are being bled in this sense. Again, like the impact isn't being felt by the company itself. If you want to see the company move forward with something, and whether it's 86 million or not, but like there's got to be some sort of stick.
All right, thank you. Thank you.
Chair Hahn?
Good afternoon, Dr. Mark. There are so many things you said that I want to engage in conversation with you on, because there's a lot of points I agree, and then some that I question, you know. So the case before us today is about, you know, an $86 million disallowance on prudence and harm. You know, is that the right number?
Right.
You know, the difficulty that I have with, you know, and why maybe the commissions before haven't made a disallowance is because you make an $86 million disallowance and access to the capital markets gets even harder. And making investments here in Missouri, trying to attract capital here, gets harder rather than easier. And an already constricted capital environment, you know, if we want them to build, it doesn't necessarily send the signal that we want you to build here. And so that's, you know, so maybe the question is the $86 million, it's actually maybe something else. Like, how do we actually make the IRP process matter instead? So right now, the commission doesn't necessarily, you know, approve IRPs necessarily. Maybe that's something for consideration moving forward, because to me, the stick in this case doesn't incent the actual behavior that we want to incent. We want them to put steel in the ground. It makes them putting steel in the ground even harder. So I'm trying to figure out what is it that we can do instead that actually incents the behavior that we want to incent. I don't know if you have thoughts around that.
These are great points, great questions. We've actually given the whole paradigm shift of doing pre-approval, you know, a lot of thought. It is definitely a change in how we've regulated utilities here in Missouri. I can find pros for it. Well, the easiest way to say this is you look at our track record with trying to find anything imprudent. It's damn near impossible. You know, we build a record. Hell, our record dates back 6-7 years now. We've been filing this stuff, and we do. We sit there and file it, be like, well, we'll be able to use this in some future prudence review. So, you know, there is an argument on pre-approval, but it's trade-offs. I mean, it really is trade-offs, and you're talking about a lot of forecasting and effectively looking at it. But I would 100% agree that today's IRP process, and the easiest, like, sort of canary in the coal mine is in the history of the IRP, I can only think of one example where the IRP was contested, and it was the first one. It was Amerant's, and that even settled out. Anytime that anybody objects to how something is modeled, it effectively goes to the commission and they say, okay, we'll do it next time. It's a model, just do it next time. And the problem, you know, and if you're not deep in the IRP, you can't really appreciate some of the nuances with this. So when we're talking about like modeling the IRP, and when Evergy says, well, our model said we'd be fine and we'd be better off just relying on the market than building. Under what assumptions? Because, you know, we've got an assumption that says, what if gas prices were really low? And then what if they're just like they were last year? And what if it's, you know, really high? All of those produce different outcomes. And that's one of the reasons why, as a commission, and I think was the right decision, you're not ruling on the prudence in an IRP, right? It's a modeling exercise. So is there a path forward on that? Yeah, I mean, we can explore that. It's a different skill set, and and instead of probably doing it on the back end of these prudence reviews, we'll probably be litigated intensive on the front end. you know, yeah, I don't know if I answered the question or not.
You
but-
did. It
okay.
was really helpful, and so maybe in the future we can explore that a little bit more. You also mentioned something else, which was the Kansas legislation that recently passed, and as you know, I've followed it a little bit too, and all else equal, watching that legislation pass, if I were Evergy, I would be building in Kansas.
Mhm.
And, you know, if we learn anything from RTO experiences, it's that borders matter. And so what, from your perspective, do you think we can do to incent building here in Missouri?
I don't think it matters. I mean, you want my honest to God opinion, my job is really twofold, to have a healthy degree of skepticism, you know, with what's put forward here, and to try to find the least cost point. Like, the beauty of the RTO market is just that. You're able to go ahead and lean on the market and to deal with that if it's done correctly. I'll give you the example, and I made this argument with wind in the Ameren case, when they built High Prairie. As a general point, I said, our wind profile is not particularly good in Missouri. I mean, it just is what it is. And we needed the capacity, or the energy. Well, stick it in a state that does. Iowa's got great wind. If we can find a place there, and if that is going to produce savings, in the number one, overwhelmingly, like, point of concern, I think, for the commission, at least for our office, is just at the end of the day going to be reliability, right? So, yeah, jobs, having the tax base in there, those are all nice extra benefits. But if the reliability's not there, then you know, at some point there'll be pitchforks in the streets because we can't afford this stuff.
Thank you.
Chair Hahn, thank you. Any further bench questions? I believe I have a few. Dr. Mark, is there any mechanism for the commission to approve PPAs similar to the CCN process for plan additions?
No.
If there were, I mean, would a mechanism to approve long-term PPAs eliminate OPC's issues related to PPAs and FAC prudence reviews?
Oh, yeah. So I want to just clarify something. I mean, I'm largely indifferent to the PPAs as a whole. The concept of PPAs, it's the type of PPAs that you're entering into. And then the issue that we took with was the take or pay wind PPAs that we've been exposed to, you know, so much. Evergy, and I think correctly states this, is that there's just not a lot of options out there in the SPP right now to do PPAs. Like, that's just the reality of the situation. If the company came in and said, hey, you know, such and such co-op out of Oklahoma wants to go ahead and, you know, putting up their natural gas plant, you know, for sale or as a PPA, man, we would absolutely entertain that and go through that process. But we're open to anything that's going to stop the bleeding.
Could I direct you to your rebuttal on page 5? And if you'll let me know when you're there, please.
I'm there.
I believe you have a table 1 on there that's confidential, and I don't want you to get into anything confidential. But can you confirm that the energy generated from the PPAs are included in that table?
Yes.
Okay. And in that table, the dollar amounts in the non-firm short-term energy and off-system sales revenue columns are cumulative for the entire period of the prudence reviews. Is that correct?
Yes, sir.
Okay, thank you. I think those are all the questions that I have. Any further bench questions before recross? Hearing none. Any recross based on bench questions, Mr. Keevil? Ms. Whipple?
No, thank you.
Redirect.
I'm going to try and keep this brief, and I'd like to start by addressing a question that you received from the chair, which I thought was a fantastic question. You know, she brought up that $86 million disallowance and the impact that would have on Evergy's ability to build and all their other alternatives. You recall that conversation?
I do.
Is there another way, or is there anything that we could do to the FAC itself that could potentially affect things moving forward that doesn't result in an immediate disallowance?
There is. We have a risk-sharing mechanism right now that's 95.5. Obviously, that's worked for some utilities and not others. And I think this is a clear example of a utility where that risk-sharing mechanism is not incentivizing the company to look out for ratepayers as well. One avenue would be a rate case, an upcoming rate case, where you could go ahead and revisit that 95.5 rate, that FAC sharing mechanism. That would seem eminently appropriate and another way to address it. Because then at that point, the company would have skin in the game on those margins. Right now, there's just no skin in the game.
You got a series of questions regarding potential changes to the IRP as well. You recall that?
I did.
And to be clear, are the companies required to follow their IRPs?
Are they required to follow their IRPs? No. I mean, what'll happen is if there's a material change to their IRP and it is something that immediately needs to happen before their next annual update, they'll file to go ahead and amend that.
Okay, run the last one, I think, very simple, and this is for my sake, just so the record is clear. You mentioned the interconnection queue. Can you please just give a brief definition of what that is and what you were referring to for the sake of the record?
Southwest Power Pool's got a website. You Google generation interconnection queue. I think it's the first hyperlink that pops up. It'll take you to a software application that shows the entire SPP map. And there's drop-down boxes that effectively you can control for the utility, the type of generation, and a handful of other things. That's sort of our sanity check as to, well, how serious are we about moving forward with something? Where are they planning on, putting that generation moving forward? Empire's there, Evergy's there on the Kansas side, on the Missouri side, and everybody else that participates in SPP. But that's what I mean by that. It's that generation interconnection queue, and it literally is just hundreds of applications for future generation that may or may not get built, but those SPP regulators are effectively going through each of those applications and approving it or not.
All right, I have no further questions. Thank you very much.
All right, Mr. Kleiser, thank you. Dr. Mark, thank you very much. You may step down. And I believe that is the end of our witnesses. Is there anything further from either the bench or the council before we adjourn?
No, thank you.
Right. Hearing nothing? I'm sorry?
There are some procedural matters that we need to take up, I think. For example, setting a date for late filed exhibits, but I didn't know if you wanted to do that until after the bench had.
I can certainly do that. I mean, we can do that on the record if you'd like, with or without bench. I mean, you're talking about some sort of parameter on late filed exhibits, late filed objections. Is that correct?
We just need a timetable and
Sure.
to reconfirm that the existing schedule for briefs is the same. There is an existing schedule for briefing, correct?
Correct.
Right. And we're not changing that, correct?
Correct.
Okay, yeah. All we need is a deadline to file objections for the pre-filed exhibits, or the two that we've got marked, I think. That would be the only request I have. Thank you.
Sure, and I can issue an order, perhaps tomorrow, that would give the parties some guidance on that. Anything further from the bench or from Council, Mr. Kleiser?
One last thing. I
That's all right.
apologize.
That's all right.
Do we have a deadline for the transcripts?
Madam Court Reporter? And how about we do that off the record so she can talk more easily? Thank you. Anything further from the bench or council? All right, thank you very much. We are adjourned.